for listing on contempt matter. And next week, any date will.
Next week. Any date?
4, 5, 6, 7.
All right, 6th.
Oblige.
Please, Your Lordship, I beg to mention for listing one petition for withdrawal, Lordship.
Tomorrow?
Lordship,
Yeah.
deeply would. May please, Lordship, with the consent of others, I beg to mention item number 6, Lordship.
6.
Yes, Lordship, the matter may kindly be listed after 2 weeks, after 12th of August.
You are for the respondent.
No, Lordship, I'm for the petition.
Item 6. Who's for the respondent?
Respondent.
You have taken consent.
Yes, Lordship.
Joint request matter stands deferred to be listed after 3 weeks.
Lordship.
Yes.
May it please, Your Lordship. Now, Your Lordship, in item number 37, we have filed an objection yesterday, Your Lordship. I may be allowed to bring that on record, Your Lordship.
Why you filed it yesterday?
Yesterday, because Your Lordship,
37.
yes, Your Lordship, there is an IA, Your Lordship. We have filed our
37 to
objection.
be listed on next available day. Friday, Monday, whatever date you want.
No, my lord, there was some urgency with regard to the.
But you filed it yesterday.
Yesterday.
So if you express urgency, you should file it within the time allotted. Matter be listed on Monday, along with the what? Objections.
Let the matter come up, then Your Lordship may.
But you have filed it. Do you
Yes,
want
we
your
have-
objections on record or not?
Yes, Your Lordship.
All right. Item 37 be listed along with the objections stated to be filed by the opposite party in IA number so and so. Registry to trace out the objection stated to have been filed and connect it to the case record list on so and so date, Monday. Yes.
Well, that victim mention for listing a matter for admission, my lord, is transfer matter. Petitioner is enjoying the stay order since February, my lord. And last listed on 6/6. Maybe on next Monday, my lord.
Next Monday, all right.
4th.
4th.
May I please say, I beg to mention for listing my lord, admission matter on Friday, my lord. Matter relates to the promotion, my lord. And it was last posted on 19/5, my lord. And returnable was, my lord, 8 weeks. Already 10 weeks over, my lord. Friday, my lord.
All right, Friday.
Oblige, my lord.
May it please your lordship. Lordship, I beg to mention for listing a contempt petition for Monday, lordship.
Monday.
Oblige your lordship.
May it please your lordship. Lordship, in item number 14, we had filed a reply.
Item
Item number 14,
1-4.
1-4. We had
Yes.
filed a reply, your lordship. Same may be brought on record.
Let it be on record next week or Friday or whatever date you
It
want.
is a small reply or
Whatever it may be. If you want it, then let it come in its proper form. Item 14.
then let the matter reach, your lordship. Let
You
the-
want your reply or not on record?
I do want it, your lordship. but,
Item 14 be listed on Friday, along with the reply
Lordship, there is
stated to be
actually
filed to
urgency
the
in the-
affidavit in opposition.
It's a reply. It's a small reply.
Reply to what?
Reply to their opposition.
Reply to the affidavit in opposition filed with the petitioner. List
Your
on
lordship,
Friday.
there is actually urgency in the matter. Then let the matter
Friday.
reach my senior will.
Let it be on Friday? Yes.
May I please, Your Lordship. With the consent of the Presidential Lordship, I beg to mention item number 35, Lordship. Next week, Lordship, any day. On behalf of GC Pegu, Lordship. 35. Yes.
35.
And next week, any day. Lordship, let it be on Friday because it is the matter pending the area payment. Payment is held up.
All right, Friday.
Friday later.
35 be listed on Friday. On the request made by the counsel for the respondent.
On behalf of GC Pegu.
On behalf of Mr. GC Pegu, Mr. H. Raman appears for the petitioner. Friday.
35.
Lordship, I beg to mention a read petition also. Maybe listed on next week on 6th, next Wednesday.
What is the matter?
Lordship, pension matter, Lordship.
Sixth.
Please, Your Lordship. Take the consent to other side. I beg to mention item number 12, Lordship. Kindly pass over the matter for vote, Lordship.
Item 12.
Yes, Lordship.
The request made by the petitioner stands passed over for the day. Yes.
May I please your lordship. I beg to mention item number 8, lordship. I'm for the petitioner, lordship. I have taken consent from the other side. I beg for pass over for that.
Item 8
Yes, lordship.
stands passed over for the day.
Deeply obliged.
The mention made by the counsel for the petitioner.
Mention item number 1 and 33. Kindly adjourn this matter for 2 weeks.
1 in 33.
Yes, my lord.
1 in
33.
1 in 33. Stands adjourned. On a request made by Ms. So and so. enabling the petitioner to make alternative arrangements. Yes.
Lordship, I beg to mention number item 19.
Hmm?
Item number 19,
19.
19.
Yes. What is your prayer?
Yeah, in this case, we file sent affidavit for waiting. This kindly 3 weeks time.
You are for the respondent. Anyone for the petitioner? Item 19 stands adjourned to be. On whose behalf are you making a mention?
Yes, law score.
Huh?
Yes, law score. GCC.
Yes, law score. Matter stands deferred to be listed after 2 weeks. Yes.
Lordship.
May it please the Lordship, I am paying for listing one deed petition for orders, non-division of pension Lordship. Monday or Tuesday, any date Lordship. Pension
Let it be on 6th.
6th of Lordship.
Now, this lordship, I have to mention one pension matter. It has been listed. It was last listed on 25 for.
11th?
Okay.
Lordship, I beg to mention for listing Lordship. There is a 2 matter. Both are pensionary benefit.
11th.
May it please your lordship.
September. November. Yes.
Lordship, regarding this matter, can this matter be taken after some time? Because the main arguing counsel is in court number 1. And I believe Mr. K. N. Chaudhary is also on the, in the arguing the same matter.
No, despite the stay order from this court, my salary has been held up.
All right. After some time.
So, very much.
Lordship, on last occasion also, the petitioner was not present, Lordship, and they have not served us extra copies also.
None appears for the petitioner on hold. Ms. M. Bhattacharya, Learned Counsel. Government advocate represents the respondents.
And for 2 and 3,
The
Lordship.
respondent 2 and 3, Mr.
for 1.
Appears for respondent 1. On the last occasion. Also, none had represented the petitioner. So it is further submitted by the respondents that although notice were issued as far back as
This was on 7/1/2019, Lordship, notice issued.
7/1/7/1.
2019, Lordship. 7/1/19. Notice-
7/1/2019. Extra copies were not furnished. Petition. It appears that the petitioner is not interested to pursue the present writ petition any further. Accordingly, writ petition stands dismissed. For non-prosecution interim orders, if any stands
They
vacated.
are seeking, my lord, that reservation. That is, my lord, in the Gambras, my lord, there is no reservation.
You're dismissing it for non-prosecution
Lordship.
interim orders, if any stand vacated.
Affidavit, my lordships, the last occasion of director, my lord, already been filed, my lord. It been filed on 2019.
Let's just see.
Item 5.
Lordship, my senior Mr. Naik is on legs. She may take up the matter after some time.
Sometime.
What's okay?
May I please, your lordship? Lordship, can this matter be taken up after some time?
Every matter can be taken up after some time.
Lordship, the council is on legs.
We'll hear the petitioner, let us see. Yes.
Yes, your lordship, this matter basically, the petitioner who was appointed, he was appointed as as a blacksmith, but he applied for both the post of electrician and black, and he was appointed as blacksmith. Then your lordship, ultimately, he was terminated without giving any notice. On the last occasion, your lordship has passed an order indicating that there could be an advertisement wherein the post of blacksmith and electrician may be in two different posts. So maybe he has applied for both, or in this petition, we have only annexed one advertisement, but there could be another advertisement from the record. Your lordship has seen that. So therefore, your lordship has directed that if there is the other advertisement, that should be brought on record. Now your lordship, only thing that requires to be seen is whether, yes, it could be whatever it may be, but the only issue is that his termination was without any notice, and not even a notice. Nothing has been given to him. Straight away terminated. They said that since you are being appointed as electrician, we do not require the electrician, so you are terminated. So that was what has been given as your lordship will find the order at page 44. That's mainly, it's not termination, it's that the appointment has been cancelled. After being appointed for about 3-4 months, he was working salary paid, and
But
even
there, I think the government wanted to say that there is no post of blacksmith
no, they advertised for blacksmith.
in Tezpur.
Yes, and and what happened, that page 45, he was appointed there. He was allowed to work as an electrician. He is electrician. He was allowed to work as an electrician because there is no
So
blacksmith.
where is the appointment order?
The appointment order, lordship will find at page 27. 27. He was appointed as a blacksmith, and then he was allowed to work as an electrician. Blacksmith post is not there. He applied for both, your lordship. That is also there. I am showing it. It was there. Page 18, he applied for both blacksmith as and electrician. There were two departments, one is DME and one is DHS. The director of medical education for the blacksmith and director of health services for electrician. He was appointed as blacksmith, though he has his eligibility is for electrician, but he was allowed to work as an electrician. And then they don't say that they do not have the activity of blacksmith functioning. So they have made him electrician. Now they are terminating him without any rhyme or reason, your lordship.
Where is your that certificates?
Certificate, your lordship? That electrician certificate, page 12. 12-9. Page 12. And they have also, I think, annexed that. Don't you December. Here, electrician is given you. And in page 55 also, we have annexed the certificate. So now your lordship will kindly see the admit one, at page 18, in both the department, there was an application, and your lordship will kindly see at page 19. The most important part is 19, your lordship. He was called for both blacksmith and electrician in the interview. That your lordship find at page 19, the last paragraph.
But he did not have qualification of a blacksmith.
He did not have the qualification of a blacksmith, so he applied. Maybe he has applied for both. He was called in the interview, and interview was held for both electrician as well as black. He should have been appointed as an electrician, but he was appointed as a blacksmith. And then he was allowed to work as an electrician. Then they, your lordship, terminated his, cancelled his appointment. And that was a substantive appointment. I had to go to page 19.
Yes.
In the admit card, specifically, both the directorate held the, your lordship, interview for both the post. They know, they have the qualifications. We have submitted that. They should have called him for, and in page 20 or
He was shortlisted for what? Blacksmith or?
he was shortlisted for blacksmith. That's where that was. Your lordship will see at page 21. This is the notice. He was shortlisting first. First, I think he was initially, yes, written test. This was the written test, where at page 22, blacksmith, your lordship kindly see, blacksmith, the second number 10315-308. The petitioner's admit card number is 10315-308. They put him in as a blacksmith in the first test, written test. Then your lordship will kindly see at page 24, that is the final selection. At page 25 in blacksmith, he was selected. On the basis of his documents, your lordship, he was selected. And even they have appointed as a blacksmith. And there is they have specifically stated verification of documents. They verified the documents because at page 21, it was specifically indicated that he will appear in a skill test and document verification. Then he appeared in the skills test and document verification, and at page 24, he was selected as a blacksmith. Now, he is selected as a blacksmith. Whatever he is selected, we are not on that. Then, your lordship, they appointed him as a blacksmith, but he was allowed to do the work of a technician electric. So, he was doing electrical job. Now, they said blacksmith is not there. We have used him. Suddenly, out of the blue, they cancel his appointment and saying that you do not have the qualification of blacksmith. So, why did you select me as a blacksmith? At least I'm entitled to a notice, your lordship. It's a substantive appointment. That's it. That's the case.
Yes. What do you say?
What's it, the council is on legs. Let him be here.
Council is on legs. What can be done?
On the last occasion, your lordship, I have also provided two judgments of the Honorable Supreme Court where it says that in such cases, your lordship, at least there has to be a notice. And
Where is your appointment order again?
appointment order, page 27. Then your lordship, he was paid the salary also. He got his salary also.
Yes. Okay.
And even the NPS was also open. I have annexed all those documents.
What
Subsequent,
judgment are you relying on?
in fact, I think provided two judgments. One is an old judgment of, one is the case of 2010 to SCC, Kamal Nayan Mishra. And the
For
other
what proposition?
judgment
For what
was the
proposition?
new, I have given those copies. Your
We have the copies.
Yes.
So what proposition are you pressing the judgment?
I'm trying to point out that without inquiry, without notice,
Hmm.
substantive post, in a substantive post, a person cannot be terminated That's basically because 311(2) has to be complied with by the court. So in this cases, your lordship, I'll just refer on the paragraphs. In Kamal, I can't prove more letters. Kamal Nayan Mishra, I was relying in paragraph 15, 15, 21, 24, and 26. Here in 15, para 15, I'll just read a confirmed government servant because he is a confirmed appointment. He is the holder of a civil post entitled to the benefits of safeguards provided under 311 of the Constitution. He is not a probationer. It's a substantive post. That is why the court says that he is entitled to the safeguards under section 311. Second part is, on the other hand, probationer does not have that substantive right. I am not on that because he is not, admittedly, is not a probationer. Then in para 21, it has stated no term in the attestation form or any consent given by a government servant can take away the constitutional safeguard provided to a government servant under Article 311 of the Constitution. So even if, your lordship, there is something which I have consented which may not be correct, or which is, even if I say that I can be terminated or whatever it is in a form, I sign it, then also they cannot do it without following 311.
Yes.
Then, your lordship, para 24, the termination of appellant without an inquiry or hearing was illegal and invalid. In the normal course, we would have said that part, your lordship, disciplinary proceeding part is given with regard to that case. So basically these paragraph 15 and 21. And the second case, that is a new case, Swati Priyadarshini, that is of 2024. Here I was referring to para 34 and 36. 34 is actually an earlier judgment which has been followed. It's a long paragraph. In this paragraph, your lordship, the court has stated in what way, in which cases 311 has to be followed and in which cases it need not be followed. So that was specifically there. So in the page, the whole paragraph I'm not reading, your lordship, the part which is required to be in this matter, is page 21, your lordship will kindly take a page 21. The same paragraph continues from above. Here your lordship will find in bold letters, top bold letters and second bold letters which starts. I'll just read from there. The court has to apply the two tests mentioned above, namely one, whether the servant has a right to the post or the rank, and whether he has been visited with evil consequences of the kind herein before referred. If the case satisfies either of the two tests, then it must be held that the servant has been punished and the termination of his service must be taken as a dismissal or removal from service or reversion to his substantive rank must be regarded as reduction in rank, and if the requirements of the rules and Article 311, which give protection to the government servant, have not been complied with, the termination of the service or the reduction must be held to be wrongful and biased. So what happens in this case, if there is a right which has accrued to the person who is holding a particular post, number one, and number two, where there is some evil consequences which has been visited, in these two cases, there is no other option but to apply Article 211. If it is not applied, then there is violation. This is what the court says. And in the para 36, they finally decided that case. In view of the discussion, then the impugned judgment is quashed and set aside. The judgment of the Honorable Single Judge Swenso State revived. However, with a modification to the extent that the appellant shall be entitled to all consequential benefit, including notional continuation in service at par with the similarly situated, but with the back wages restricted to 50%. Further, in view of the long passage of time, we deny liberty to proceed afresh against the appellant. So that was what it has. Now here my case is basically that I'm holding a substantive post. I have a right to the post. You deny that right to me, and therefore I have to get a notice, and section 311 have to be. That's the only crux. And this judgment, which was taken of Purushottam Lal, which is a 1957 judgment, which has been relied upon by the Honorable Supreme Court and have come to this finding.
So what is the conclusion of the apex court here in this judgment?
In this judgment, court said that the order of the division bench was quashed and the single judge, that para 34, your lordship. Oh, sorry, 36. 36. 36, the court said, in view of the discussions herein above, the impugned judgment is quashed and set aside. The judgment of the learned single judge dated so and so stands revived. However, with a modification to the extent that the appellant shall be entitled to all consequential benefits, including notional continuation in service at par with other similarly situated employees, but with back wages restricted to 50%. The only thing that was restricted was the 50% of back wages. Further, in view of the long passage of time, we deny liberty to the respondents to proceed afresh against the appellant as was granted by the learned single judge. However, this will not preclude the respondent taking action against the appellant in accordance with law and so on. So that part we are not concerned. Basic part is that considering this judgment, in that case, it was a little bit different. And the whole paragraph 34, your lordship, if I read the whole judgment, para 34, it has dealt with all these issues in toto, and then only picked up this. I am picking up only my part. That is what I am trying to. Otherwise, in read the whole judgment where your lordship, it has stated various, your lordship, in case of even your lordship terminations where dismissal removal was with regard to negligence, misconduct as well. Everything has been taken into consideration in this judgment, even negligence and all. And finally, your lordship, it came to a finding that there are two options when there is a, in my case is with right to the particular. I do not have any, your lordship. In this case, there is no evil consequences. But question is that this, I have already a substantive right which is accrued to me after being appointed after a due selection process. And it is not that I have done something. I have not done. I have given my records. I have given my documents. They have verified. They have appointed. They should have appointed me as a electrician.
But you're not qualified to work as a blacksmith.
Okay, I may not be. Then why you have appointed me? Number
Maybe
one.
There's an error in the process of appointment. Are they not entitled to correct it?
They are entitled to correct it. If they are entitled to correct it, very well. Why they are not entitled to give me a notice
Right.
that this is wrong? You have to.
How does it change? All right, you are entitled to a notice. Let us say prima facie, you are entitled.
Change the whole issue because why I'm saying that, because once I get a notice, I will get an opportunity to bring my case before that.
That is what we are asking you. What is your case?
That this whose mistake? Just because their mistake, why should I see?
So you go
once I get into a particular post,
their mistake, you don't dispute the fact that you are not qualified to hold the post.
I am qualified as an electrician. I was holding the post of an electrician.
No.
Though I was selected as a blacksmith.
No.
I was allowed to work as
Your
an
appointment
electrician.
order says you are appointed
As a blacksmith, but I was allowed to work as an electrician.
That is different. But your appointment, substantive appointment, is to the post of a blacksmith.
It was not that I applied only for the blacksmith and I was selected only for the blacksmith.
But your order is for the blacksmith.
Huh? Yeah,
you are appointed as a blacksmith.
Yes, after. That is where I am. For example, I am appointed today.
So you are appointed as a blacksmith, but allowed to work as an electrician, which otherwise you are qualified to work as an electrician, which the authorities were well within their rights to issue an appointment order to appoint you to a substantive post of an electrician, which they did not do, whether by fault, by default, by design, we don't know.
Yes.
But to say that having appointed as a blacksmith, admittedly to the post, admittedly you do not have the qualification, and notwithstanding that you're working as an electrician, they have no right to set it.
No, I have the right. Once I'm appointed, I am paid salary. I have been appointed for a particular period of time.
No, but natural justice is not just an empty formality.
That question is whether in such cases natural justice is not required. And secondly, your lordship, once a person is appointed in a substantive post after an advertisement, after selection process, due verification of documents, whatever skill test
there's some mistake.
Just a moment.
There's some mistake.
That person gets into a job. You may approach the proper forum to
sue them for compensation, etc., damages, a different
That,
issue.
that part will come
But
if at
to
all.
say that you will continue to hold the post where you do not have the qualification, admittedly,
That-
it's
that
violative
is-
of the
that is where
provisions
your
of law, because there could be somebody else who's qualified to hold the post and who's.
That is where your lordship, the whole issue is.
Hmm.
Person has been put into a particular post. He has a right accrued to that. Fine, it may be, your lordship is correct. There is an error, they have done it. So for that, why should we suffer?
Show
And
some
this person
authority if
might
you-
have, for that reason, he might have so many, your lordship, like if a person gets a job, he is a regular appointee. Many things
But
come
this is-
along with
This
that.
is public.
Suddenly, out
These
of the
these
blue, cannot
these
do it.
appointments are to, these are public appointments to public
Yeah.
posts,
That is the
selection by
reason.
the government.
If it is a
So
pub-
every citizen has a right to compete, qualified.
exactly, if there is a right to compete, it is not that he was alone.
Hmm.
There were so many other
It
candidates.
is their fault.
They selected him on the
We
basis of
accept your
his qualification.
submissions, we accept your submissions that it was not your fault. You did not, there is no one can attribute that you are responsible for getting into this.
Then
But-
what is the remedy for that?
It's
That
for
is
you
there.
to educate us on that.
My remedy, I have stated that they have to give a notice before any
All
termination.
that they give you a notice. How does it improve your case? Can you say that you are otherwise qualified, or that document was available, or you had acquired qualification in the meantime
No,
to hold the
apart
post of
from
a blacksmith?
requirement of qualification and all, but the question will, at that point of time, he can place his case that this is the reason I was working there. Let me continue with that, whatever it needs. Because he was he was working with the particular office where he was allowed to work. It was not that blacksmith post was there. There was no post of blacksmith where he was
That's
allowed to
right.
work.
All the more reason why.
Then why did he?
Why should we?
disappoint it?
Why should we indulge in exercising our
That is where
discretionary power?
if a notice is given to him, he could have pointed out these things, your lordship.
He could have.
Before
but
the particular department, and I don't know what could be the answer out there. It could have been in his favor. I don't know. Anything can happen. We cannot assume or presume something.
If you don't know, who will know? You
can-
are supposed to know and educate,
No,
address the court on
what
this.
government will do if I come and place my case
Yes.
before them.
Worship, let the council be here.
And
How long do we have to wait? Tell us that.
one more thing, your lordship, I will just point out. For example, your lordship, since he was selected as a blacksmith, there was no post of blacksmith at that particular office where he was selected. He was there. He was working as an electrician in that particular place. They could have converted it, the post. No, that is what I am trying to point out. Not like these are actually, that is why assumption and presumption could have happened there. So at least the notice should have been. These are the reasons why a notice or a so cause should have been given, so that these things could have been placed, something, or else there might have been some post somewhere where he could have been attached. These are things which the government will do. We cannot decide it. So that is the reason, and normally a notice or a so cause is given, that there might be some opportunities here and there which can be looked at. If it is not there, finally they decide, that's a separate issue. But just because you appoint someone, tomorrow you say, no, you're not qualified, go. After maybe this could have been done after 3 years, what would have happened then? These are the issues, your lordship. Look, as a whole, looking on one way in favor of something, it is correct. But the other way also, something has happened. A person has been appointed. He has got appointment. He's getting his salary. He must have gone into some loan. He must have done something. So many things, your lordship. These are issues without a notice. That is the reason, your lordship. Natural justice is for that reason is given. And what would have happened had they issued a notice to him, your lordship, before terminating? Same thing, same issue could have been brought up by following the due procedure of law.
All right, yes.
Worship, let the council be here.
Half an hour. By the clock. Half an hour.
Okay.
Otherwise, we're closing the hearing.
Yeah,
Yes.
worship. Yes.
Let him come. We'll
Yes.
let him say, let us hear what he has to say.
Yeah, Lordship. Lordship, this situation is in connection with the disciplinary proceeding. Prisoner was terminated in way back in 2012, and thereafter appeal was dismissed, appeal was filed, and that was disposed of in 2024. My lord, pleading is almost complete, but some pleading is lacking. So I want to file an additional affidavit, short affidavit.
You want to file?
Lordship.
Right.
With
Yes,
regard to some vital issue.
Mr. Monto, learned counsel for the petitioner submits that will do. That there are certain instructions which
Yes.
you'd like to, on the basis of which you'd like to file an additional affidavit, as the same would be relevant for the purposes of deciding
Yes.
the present list. MSM thus standing counsel PWD does not object to the requirement list after 3 weeks.
Lordship, 1 week.
1 week.
Lordship.
All right. 1 week. List
Thank
after 1 week.
Yeah.
Yes.
Please, your lordship.
My lord,
Here in this case, my lord, the read petitioner is a data manager.
Is that?
Data manager. Her appointment letter is at page 16, my lord. She was appointed on 12/5/2012 on contextual basis to the post of block data manager in CPJ BPSG. My lord, the petitioner is before your lordship by challenging the transfer order, which is at page 19 Annex 3.
Yes.
Here, kindly peruse, my lord. The following employee working under National Health Mission Assam is hereby transferred and posted as below. Petitioner name is in column number 3rd, and her position is block data manager. Place of present place of posting Darang, Sipajhar, my lord, and she has been transferred to Lakhimpur. Kindly peruse one thing, my lord. In this transfer order, no whisper has been made regarding public interest and administrative exigencies. Nothing, my lord. Now, my lord, thereafter, she represented before the authorities, White Annexure 7, page 33, my lord.
33.
Page 33, Annexure 7.
Yes.
My lord, she stated before the authorities that her mother is ailing and she has to look after her. And from Sipajhar to Lakhimpur,
Where is your appointment order?
appointment order is at Annexure 1, my lord, at page 16. This is the type copy, my lord. The original is at page 17. Her engagement.
Where is the agreement? Agreement of contract?
Agreement of contract. Annex 1.
My lord, I have not annexed that, my lord. Go ahead.
Anyway, then,
Then, my lord, they file affidavit in opposition. In fact, they filed two affidavit in opposition. The first one, which is at page, starting from page 34. Kindly peruse paragraph 4 and 5 of this affidavit, which is start at page 36.
yes.
In this affidavit, my lord, they have admitted that transfer order was passed upon receipt of complaint. That the deponent begs to state that here the petitioner was transferred in accordance with the order dated 27/9/2024. This transfer was prompted by a formal complaint received from the district commissioner cum chairperson of the district health society Darang district as outlined in their letter dated 10/6/2024. That the deponent begs to state that the complainant detailed several concerns regarding the petitioner's performance. Especially, it was reported that the petitioner had shown consistent irregularities in filing, in fulfilling her duties, and her performance has been deemed unsatisfactory. Despite multiple reviews at the district level, she failed to provide justification for her lack of progress or improvement. Furthermore, the petitioner had repeatedly failed to upload key reports both timely and accurately. That the district health society had issued several warnings to the petitioner regarding these issues, yet to discernible improvement was observed. Consequently, the district commissioner has requested that appropriate action be taken, including the transfer of the petitioner to another district. So kindly peruse annexure 1 to this affidavit at page 38. Here, my lord, this is the letter from Deputy District Commissioner cum Chairman to the mission director. With reference to the subject cited above, it is observed that Ms. Swencho, Block Data Manager, Sipazar APSC, is found very irregular in her duties. Her performance is not satisfactory at all. Nothing can be justified by her in any review meeting held at district level. Various reports are not uploaded timely and correctly. We have warned her several times, but no change notice till date. Therefore, you are hereby requested to take necessary action like transfer. Requested to take necessary action like transfer, which clearly shows that the transfer order is punitive in nature. And when the transfer order is punitive in nature, that is hit by malice of law. And my lord, that is it is an admitted position, my lord, and is liable to be interfered with, my lord. Against that, my lord, I have filed my affidavit in reply. I have, in fact, filed two affidavit in reply because they have filed two affidavit in opposition. And kindly and my lord, the law is well settled, man. A punitive transfer, there cannot be any punitive transfer. No opportunity was given to the petitioner or no memo was issued. My lord, kindly come to paragraph page 55, my lord. Page 55 of my affidavit in reply.
Yes.
If there was any lack on the part of the deponent, how come she served for such a long period of time in the block without any complaint from anywhere? That is the reason she has not been served with any so-called notice till date, as she sincerely did her duties and submitted the reports on time. After giving her best service, now why such an allegation has been leveled against her is best known to the respondent. The deponent denies regarding this, as the deponent was never given any warning nor any show cause was issued against her from the District Health Society, as no need arose for it, as the deponent had been doing her duties with utmost sincerity and had been submitting the reports within the stipulated time. In fact, after receipt of complaint from the District Commissioner via letter dated 10/6/2024, the deponent was not intimated regarding the complaint, nor was the deponent given a fair chance to defending herself.
This page 38, you mean to say, is incorrect on facts.
Mine,
Page 38.
mine.
Yes.
But as per order of the this honorable court on 11th March, my lord, we have filed an additional affidavit in opposition and bring on record the transfer policy of NHM, my lord. The general condition 2, my lord. At the same time, the mission director NHM reserves the right to transfer or depute any employee at any time if the need arises in the interest of NHM program.
Where is the contract of service? Where is the contract of service?
No, that I have not that annexed that one. If necessary, I will bring it.
Bring it on record. Let us see
Ma'am.
what are the service contracts.
Yes, ma'am.
Whether transfer is one.
Yes, ma'am. I will do that. 2 weeks time may be given.
2 weeks time. Heard counsel for parties. The matter pertains to the order of transfer issued to the petitioner, which is assailed in the present proceedings during the course of hearing. It is the question of, during the course of the hearing, the service contract entered by and between the petitioner and the respondents was required for perusal of the court. Stop. However, counsel for the petitioner submits that the same is not available on record. He prays for 2 weeks' time to bring it on record by way of an additional affidavit. Prayer made is allowed. List the matter again after 2 weeks. MSA Bora appears for the state. NHL. After 2 weeks.
The date may be fixed.
Bring it and make a mention.
Yes, ma'am. Obliged, ma'am.
Item 11.
Yes.
আজি আপুনি ক'ব নে নক'ব? তুমি কৰিলে তাৰপিছত মই ৰিপ্লাইটো ঠিক কৰি দিম। Because the other day, if I'm not wrong, the other side had some more submissions to make. That was the.
No,
If I have to start, I am ready to start.
Before he starts, I first must convey my apology for giving a wrong statement last time. I said 30th July. Actually, last extension is up to 30th of September.
Last extension.
Last extension goes up to 30th of September.
Is there any proposal to?
There is a standing cabinet decision, which is a part of our affidavit, which says it was about a year back that further extension will be for 1 year or APSC selection, whichever is earlier. Page 264.
What is the process of APSC selection?
The interview, the advertisement was issued, and now it is a stage of interview.
10th of August.
Interview not yet held.
Page 137.
10th of August for screening test.
Screening test will be written. Thereafter interview.
Yeah.
So therefore, I don't see any possibility of your apprehension materializing before 15th August, Mr. Pathak.
31st of September, 30th of September.
30th of, because at page 137, there is a notification.
We'll have it on 19th then.
Man,
19th of August.
19th August.
No difficulty. No.
10th of August is the screening then interview.
There is a process will be going because after screening phase, there will be notified who will be qualified. So there will be at least 1 month.
So before 31st, 30th of September, I think the recruitment process would be completed.
if I can
Maybe in the
add one more thing, the process that is
September. September.
Can I add one more sentence?
Yes.
In fact, the process that is going on is pursuant to an advertisement issued in 23 or 24 for 195 posts. That is not under challenge from us. Our advertisement was in 21 under 3F mode.
No, your apprehension is that once this 195 comes in, you will be discharged.
Because of page 137, because
There
of
is
page
a-
137, they said our extension is up to 30th of September. Page 137 of the writ petition. So 30th September extension is there. 19th of August we can do. If you
Then I have absolutely no difficulty.
All right. 19th. My lord. As agreed to by council for the parties, matters stands delivered to be listed on 19th August as in view of the submission made by the at the bar that the process of selection is underway and has not been completed as yet. Mr. Pathak, KP Pathak, Senior Counsel, assisted by Ms. Ranso, appears for the petitioner. Mr. Devajit Sakia, Advocate General, appears for the state. Mr. B. Chaudhary, for the Department of Agriculture. Mr. T.J. Monto, Senior Counsel, assisted by Ms. P.P. Das, appears for the APSC.
Mr. Chaudhury's name will not be there. Mr. Mojudna's name will not be there.
We are aware of that.
No, my lord.
We have stopped recording his name for the past 2
from the
weeks.
first day.
That will happen only after tomorrow.
My lord, that is of course correct. But she is there to assist.
No, of course, we have recorded her name. We have recorded her name.
Deeply obliged.
এটা কাম কৰিব পাৰে নেকি এইখিনি দিছে নতুনকৈ আজি যিখিনি মেনশ্যন হৈ গ'ল সেইখিনি সোমাই পেলাই আপডেট কৰি দিব পাৰে নেকি সেইটো পদ্ধতি দিব শেষ নেকি আছে নহয় এটা 13 নম্বৰ
Can we talk about this matter for time being?
Time being.
Yes, my lord.
Right. Time being.
Time being at 5.
They have to produce the record today. With all the records.
So in this case, Lordship, one affidavit from the government as well as from the finance department has already filed. Lordship, if Lordship comes to the prayer portion, Lordship, at page 30.
Three zero,
yes, Lordship, writ petition.
yes, sir.
So their prayer is for implement the cabinet decision dated 4th of September 2013. So far as the petitioner are concerned, Lordship, they are non-provincialized employees of municipal board. And they are saying that this specific cabinet decision, wherein Lordship, what portion is there for provincialization of non-provincialized employees, Lordship, they want this cabinet decision to be implemented in their case, Lordship. And this cabinet memorandum, cabinet decision, Lordship will find at page 100. That is the only prayer, Lordship. Page 100 is the cabinet decision, Lordship. And the specific portion is serial number 2. Serial number 2. The proposed staff strength and to provincialize in principle 5170 posts for 5 categories of ULBs including regular scale of pay of for sweepers, along with corresponding scale of pay recommended by the 4th Assam State Finance Commission. So this has been approved by the cabinet at that stage, Lordship. It was in the year 2014. Now, Lordship, yesterday some instruction I received, Lordship, and so far as my instruction is concerned, in fact, this cabinet decision was never implemented in case of anybody, Lordship. Leaving aside no question of implementing this in case of petitioners, Lord. So subsequently, Lordship, so far provincialized is concerned, in 25 also, Lordship, one bill has been circulated that has also been approved by the cabinet. Lordship, incorporating all these issues, Lordship, I want to file one detailed affidavit, Lordship. I'm not praying much time, Lordship. 2 weeks time will be
Only
sufficient.
one that Lordship's repeated order, that last order is 24/6. They have to produce the record. Why they are suppressing the record? That is my concern. Lordship 24/6, Lordship passed an order. Their earlier order from 4/4 continuously. 11/6 also, the relevant records. Last occasion, the other advocates have submitted the records had been received. Lordship reminded. That day was submission was that records are received, only Nayak is on other side, that's why time is expired. And now they are changing the stand again. Why they are suppressing the record? They are not producing the record in spite of the repeated court order.
No issue in producing the record, Lordship. Let my affidavit come. Let that specific.
There is a specific direction in the last order.
Yes, Lordship.
You were directed to produce the records.
It will be produced, Lordship. It will be produced. If he has, my colleague has already received the record, it will be definitely produced, Lordship.
So whether received or not, if not received, you call for the records.
Lordship. But this
You
is
file whatever you want to
Yes.
file, but you produce the records.
Lordship.
There is an order, there are several orders by the court.
That is 24/11/6 from repeated order.
We'll give you 1 week's time, you file your
I'm
affidavit.
praying for 2 weeks, Lordship. I have only received the instruction. I have prayed for some detail in this regard, Lordship. Once I receive this, Lordship, I'll file my affidavit. I'm praying for 2 weeks only, Lordship.
What information are you bringing on the record?
Lordship, in fact, this cabinet decision was never implemented in case of anybody. They are saying that
Bring
implement
it on record within
Yes,
1
that
week.
much I know.
Why 2 weeks? And then there's an uncertainty of whether you are receiving information or not. Instruction from the record, from the department. We'll give you all right 2 weeks, but no
Lordship.
further.
Lordship, I have asked the department
We
why.
don't know. We don't know. If you don't file it within 2 weeks, we are
2 weeks,
closing.
Lordship, I'm filing. I'm filing, definitely filing, Lordship. 2 weeks.
And we'll also like to see the records.
Records will be with the affidavit, Lordship.
Yes, Mr. Roman?
Yes, because Lordship's repeated order is to produce the records. If they are defying the order of the honorable court, I have nothing to say. Because it is
Let us have that affidavit where they want to say that it has never been implemented.
No, that is already that affidavit, they have filed 2-3 more affidavits. Lordship.
Is it available here?
Yes.
Is that averment there that it has never been
Not
implemented?
there. It is not
Not
there.
there, not
Not there. I have
Then-
seen the affidavits already.
But other affidavits are there. Thereafter, Lordship wanted to see the records. That is the last point. So now they are not producing the record.
They want to file an affidavit to
I
bring
have
on,
not- I have
bring on
not-
record and make a
Yes, yes.
statement on oath that it has never been implemented.
Lordship.
That Mr. H. Raman, Senior Counsel, assisted by Mr. Swanzo. Mr. P. Nayak, Additional AG appearing for the state.
Yes, Lord.
Mr. Nayak submits that as per instructions received, the cabinet memorandum, cabinet decision referred to and relied upon by the petitioner. Where is the decision? Cabinet decision.
This is at page 100.
Page
Lord.
100.
It's 4th of September 2013.
Cabinet decision is not implemented. That is why before your Lordship, read person.
This is a part of the writ petition,
Yes, Lord.
page 100.
100.
Annexure B.
Which is a part of the writ petition within bracket at page 100.
An actual beep
was never implemented by the state. So we, to that effect, you'd like to file an additional affidavit to bring on record the stand of the government. So he prays for 2 weeks' time. Mr. Roman, on the other hand, submits that in spite of repeated orders by the court, the relevant records have never been produced. There are specific directions by the court to produce the relevant records, which have not been done. So, considering the submissions made, we permit Mr. Nayak to file his affidavit within 2 weeks and no further. So, the records relevant for the purposes of the case, present proceedings, and also directed by orders of this court, dated 24/6/2025. And 18/6/2025 should be produced on the next date fixed. List again.
On 14th. By 12, I am going to file my affidavit.
Let it be on 19th
Lots.
or 21st. 21st.
Lots.
List on 21st. Yes.
As per earlier
None appears for the writ petitioner. Mr.
A. Gayan, on behalf of PK Munir.
A.
Gayan, on behalf of PK Munir.
Gayan appears on behalf of Mr. P.K. Munir.
For the respondent number 1 to 5.
For the respondent number 1 to 5. The matter relates to non-payment of dues for the petition to the petitioner, and part of which have already been released. Considering the issues involved, this court is of the view that the matter can be referred to be settled by way of mediation. List again. The mediation or date to DT. When was the last date key in the mediation? 22. So 23, 24 and again there. 23rd August.
Not so please.
In 16.
Matter may be referred.
Referred. All right. Counsel for the petitioner submits that these matters can be referred for settlement by way of mediation. Mr. I. Talukdar for the petitioner, Mr. D. Bora for the state MSRR. So here for Accountant General. List on 23rd August.
Yes.
Yes.
So I think it will not work out, Lordship. There are some legal issues, Lordship, pending.
What is that legal issue? What is the matter about?
Lordship, matter is that, Lordship, the husband of the petitioner was an works as employee, Lordship. During service period, he expired, Lordship. Thereafter, the petitioner applied for pensionary.
He was
benefit.
never regularized.
No, not regularized, Lordship. Lordship, this case is more or less similar to.
You want the pension of the workers employee?
Lordship.
Of your husband who was the workers employee,
Lordship.
not regularized.
Not regularized, Lordship. More or less similar.
What about affidavits?
No affidavit filed, Lordship.
No affidavits filed, all right. This matter pertains to the claim of the petitioner towards the pensionary benefits for her late husband who served as a work charged employee under the PWT department and subsequently expired. Stop. Petitioner's husband was never regularized. Considering the issues involved and in the absence of any affidavits filed by the state, this court is of the view that an opportunity be granted to the state to file their affidavit list after 2 weeks. Yes,
May I please your lordship? Your lordship, we have not received any instruction yet.
recovery made,
Yes, your lordship.
recovery made. None appears for the petitioner, Mr.
C. Paul. C. Paul.
C. Paul appears on behalf of
APD. APDC.
APDCL MSK Fukan for
In respondent number 3, AG.
respondent number 3.
We'll also file an affidavit, your lordship.
Readings are yet to be exchanged, matter be listed again after 3 weeks.
How much?
Item.
Your lordship, senior is on leg, kindly pass over for time being.
Time being.
Item 21. Yes, this relates to non-payment of gratuity and provident fund on the ground that nomination has nobody appointed as nominee. Because under the gratuity and provident fund act, there are provisions that even legal heirs or on certificate. In fact, I have submitted the succession certificate. Therefore, it can be this. It has to be heard by this.
Where is your certificate, succession certificate?
Succession is at page, my lord. I have given it. At page 14, my lord.
1-4.
Yes, my lord. Page 16 really that amount quoted.
Yes, what is the difficulty?
Your lordship, we have filed the affidavit, in our affidavit, we have stated that since the petitioner was the niece of the deceased employee, Mrs. Simati, Ruby Saikia, late Ruby Saikia. That's why she is not entitled for pension. Otherwise, for GPF and other allowances, we have written to the AG way back in 2022 itself. And there is a honorable court's order also dated 25/2022, wherein your lordship directed us to at least give the GPF and we have accordingly forwarded all the pension papers to the AG. And then also they have not paid. That is
Who's for the accountant general?
the order. The order to the devotion.
Accountant generals. Accountant general. Wait for some time. Please.
Item 53.
None appears for the parties passed over. Second call মাৰি দিবি লিখিব নালাগে second call দুবাৰ বোলে
Item 24.
The petitioner already received the arrear pension money.
I am on behalf of Mr. M. Shoikia. Lordship, 3,49,000 has been credited in the petitioner account, but 23,000 has been getting permission, but Lordship, pension book has not been furnished to me. So Lordship, it's much needed to give permission to show pension book.
What some amount is released?
Release, my lord, and he has been receiving, she has been receiving monthly pension money. Till date, monthly pension money, to my information. Against PTO numbers,
Lordship.
my lord, general pay and account officer sent PPO number for generate to generate the PPO number to senior accounts officer. That was Delhi, my lord. And after generation,
Well, we are referring it to mediation. Sort it out. Third council for parties. Matter we refer to it. DD 20, 22nd. The কোন তারিখ আছিল last 23 is a Saturday. বন্ধ থাকিব তার আগৰ ডেটটো বদলাই দিব 22nd only 22nd of August. Yes, Mr. Someone. Is there any way?
Yes, my lord, there are recruitment rules for employees other than officers. These were not. Huh? No.
पास में लगे ना Yes.
And these are the rules for recruitment. And page 7. The 97.
Yeah.
Page 7, it was the decision taken by the NRL with regard to the categorization of these workers. Next page.
Page 7.
Page 7. April 1997. The terms and conditions of the non-management staff of numerous NRL. The next page is a list of designations proposed for NRL workmen. And grade 3, your lordship will find the fireman 3. Now that
Yes.
next, the others are the pay scale for grade 3, 1,
No,
3.
no,
Next
no.
page.
This is grades and designation.
Yes, madam.
So grade 3, you say fireman 3.
Fireman 3.
Grade 4 also there is some fireman.
Fireman 2.
And grade 5 also fireman 1.
Fireman 1.
So these are all firemen.
For all firemen.
The initial appointment is
Grade 3.
Grade 3.
Grade.
Then you become you are promoted or
Promotion, after promotion.
after promotion.
After, then 4, 5, 6.
So
like
this is their,
initial
no, so the highest grade that a fireman can go is which grade?
9.
9.
9.
How? There is no fireman post.
No, it's not there. It was subsequently, decision was taken.
Hmm.
This is the initial of 1997, when the first fireman grade was. Then these are the pay scales. Your lordship will kindly see page 18. There is a comparison given with IOC and NRL, page 18.
Hmm.
Right hand side, the NRL proposal. Grade 3. And on the left hand side, grade 4 of IOCL, that is operator D, which my learned friend has annexed with the writ petition. Operator D.
Operator D is equivalent to fireman.
There are different categories. Operator D, typist, and other also given. They have annexed. In IOCL, they designate in different way. Receptionist also grade 4 in IOCL. And chemical operator D in grade 4 in IOCL. This was sent to the IOCL for their comments. And page 29. These were accepted.
Hmm.
Page 29. These are the comments sent to the IOCL and the comments received back by the NRL. Then again on 8th of April, decision was approved. That is page 34. That is grade 3, rigor 3, fireman 3, and all. What happened, Your Honor? Lordship, in 1998, they are the first batch. 6 persons were appointed as firemen, grade 3. A dispute was raised by the union against the management regarding their grades.
Hmm.
A dispute was raised regarding the firemen's grades. It was resolved by the Regional Labour Commissioner, Central Guwahati. Lordship will kindly come to page 41 of this compilation. Last 2 pages.
Hmm.
It's a memorandum of settlement dated 16/7/2004, arrived under section 12(3) of the Industrial Dispute Act between the management of NRL and the workmen represented NRL employees before the Regional Labour Commissioner, Central Guwahati, Numerigar, in conciliation dated 15th and 16th July 2004. These are the representing management, and they are the person who are representing the union. Now, may I just read, it's a small one. General Secretary NREU made a representation before the Regional Labour Commissioner Guwahati on 5/7/2004, stating that there is anomalies in the grade of firemen recruited with higher qualification in the year 98-99. Those firemen who were recruited earlier have higher educational qualification in comparison to those firemen recruited later on
as per conditions mentioned in the advertisement. Union further has mentioned in their represent that 3 technicians, one installation technician and other boiler operator were also recruited, have not been placed in appropriate grade and demanded that they should be placed in appropriate grade. Union further stated that the matter has been discussed but could not be resolved due to difference of opinion as such requested for intervention. The matter involved in both issues were discussed and suggestions, counter suggestions are given by both the parties to resolve the issues. After prolonged discussion and suggestions made during the discussion, and finally on intervention, both the parties agreed to settle the issues on undermentioned terms and settlements. Now, next page, terms of settlement. It is agreed that 6 firemen who were recruited in the year 1998 shall be placed in grade 4 with effect from 15/12/1999, that is the date of the union raised the dispute, to the management by letter number so-and-so dated 15/12/1999, with one increment of 4% of their basic pay from the said date, and their seniority in grade 4 will be reckoned with effect from 15/12/1999 for consideration for next promotion within the ambit of the promotion policy to be finalized with the union in due course. The name of 6 persons has been given. Out of this 6 persons, except the first one, the others are the petitioners before your lordship. It is agreed that C.P.K. Roy, so-and-so, grade 6, Sanjeev Kumar Gogoi, technician, grade 6, Sanjeev so-and-so. I skip this. Number 3. It is agreed by both the parties that the settlement is full and final in respect of the dispute pertaining to firemen, technicians and boiler operators, and shall not be quoted as precedents whatsoever at any stage of time in future. Union expressed their sincere thanks to management and Regional Labour Commissioner Central for settling the issues and assured full cooperation in maintaining healthy industrial relations in the organization. So a dispute regarding their grade was raised in 15/12/1999 through their union, and that was settled, and for the first from grade 3 to grade 4 was given only 1 year after the appointment. That is on 15/12/1999 with effect from 15/12/1999. So now, after settlement of these issues, whether those 6 firemen can come before your lordship and in a writ petition ask for the grievances.
Yes.
Look, I'm sorry, but my friend is reading. I'm not having access to it. I have not been served a copy.
Your client should have briefed you on this. There's a settlement.
Had this document been with them, there is no reason for withholding those
All right, you
documents.
serve him a copy or you bring it on record.
They should
Since
bring
he's
it on
disputing
record
it.
by filing an affidavit. Whatever
He's
they,
disputing it, you bring it on record.
This is a conciliation proceeding.
Mr. A. Dhor, learned counsel representing the NRL, is placed before the court. The memorandum of settlement dated 16/7/2004 arrived at under section 12(3) of the Industrial Disputes Act 1947 between the management of Numaligarh Refinery Limited and their workmen, represented by Numaligarh Refinery Employees Union, before the Regional Labour Commissioner within brackets Central Guwahati. So, by the said memorandum of settlement, it was agreed that 6 firemen who were recruited in the year 1998 shall be placed in grade 4 with effect from 15/12/1999, i.e. the date of the union raised the dispute to the management by the letter number so-and-so dated 15/12/1999. Stop.
15, 16 July.
These 6 firemen will be placed in grade 4 with 1 increment of 4% of their basic pay from the said date, and their seniority in grade 4 will be reckoned with effect from 15/12/1999 for consideration for promotion within the ambit of the promotion policy to be finalized with the union in due course. Stop. The names of 6 firemen are indicated, and out of these 6 firemen, 5 are writ petitioners before this court. Stop. Para Mr. Dhor therefore submits that in view of these terms of settlement, there cannot be an occasion for the writ petitioners to agitate or re-agitate this matter by filing the present writ proceedings. Para. Mr. Somoa, on the other end, submits that the copy of this memorandum of settlement, this memorandum of settlement is not available in the pleadings, and
There is a service rules also.
and copies thereof have not been served on him, and therefore he cannot
Recruitment.
submit without instruction from his client. In that view of the matter, we permit Mr. Dhor to bring this deed of settlement dated so and so, along with any other relevant document which he may consider it necessary for deciding the present writ petition. So let this be brought on record by way of an additional affidavit, within a period of 2 weeks. 2 weeks. Copies thereof be served on the counsel for the petitioner, list after 2 weeks.
If your lordship pleases, my lord, can it be fixed on 26 o'clock?
Let him file. You get your instruction. Required, you mentioned. Yes.
That's fine.
Yes, it. Hello.
Typing item 2.
Make it a matter. No. No, that was the law. Upgrade because it automatically like no. Sign given daily. Yes.
My pleasure, Lord. Also, will kindly take up page 30 of the IA. The repeated violations.
But today the matter was supposed to be taken up for final disposal, my lord.
IA.
I is for non-payment of salary, but main my lord, transfer petition may be taken up, my lord. The issue of transfer has been
I am
challenged.
pressing the IA first. Because they have to pass with the contempt first.
No,
They
that's
are
not the
repeated-
issue.
Tell us.
Yes, Lord, will kindly.
Why the writ petition was filed?
Yes, my lord, that's.
Okay, Lord, the petition was filed because, my lord, there is a direction from this honorable court to give me retrospective promotion. That's order I am referring at page 30.
1-3.
30 of the IA.
It's not there in the writ petition.
It's there, my lord, but since the IA is there, my lord, I'm pressing it from the IA.
You refer from the writ petition. Let us understand the writ petition. IA is for release of salary.
Yes. No, my lord, Lord will kindly see. They are repeatedly violating this honorable court.
What are they violating? That is what we want to see.
That
Which
is what
order?
Yes, my lord, those order I want to place one.
Is it not in the writ petition?
It is in the writ petition.
So why don't you refer to the writ petition? Your IA is for direction to release salary.
Yes.
On the basis of some orders passed.
Yes, my lord.
So let us go through the orders.
Yes, my lord. But in IA, it would have been better, my lord. Anyway.
All right. Let us have it your way.
Yes, my lord.
Yes.
I'm obliged, my lord.
Which page?
My lord, the order starts at page 18. Lordship will kindly come to page 30. para 26.
Vera?
26,
Yes.
down below, my lord. Page 30.
Yes.
May I read it, my lord? In view of the above, while the impugn action of the review selection board dated 2/4/2018 and consequent order dated 2/4/18 of the department have been set aside, the respondent authorities are directed to immediately hold another review DPC to consider and promote the petitioner to the rank of associate professor. Such promotion is required to be given effect from 9/9/2014 as directed by this court in the judgment and order dated so and so, passed in so and so. Consequently, all notional benefits, including the seniority and proper fitment, are to be given to the petitioner in the rank of associate professor from the said date 9/9/14, para 27. The conduct of the department clearly appears to be unreasonable and vindictive, and as such, the aspect of imposing costs was also considered. However, this court has reluctantly decided not to impose cost. Now, my lord, this order was passed on 16/5/2024. And my lord, they're still sitting over the matter. Then, my lord, to overreach the direction contained in this order, lordship will kindly turn to the next page, page 32. This has been passed on 7th of February 2025. Pending receipt of report of the expert committee constituted to facilitate compliance of the order of the Honorable High Court in WPC number so and so for holding review DPC for promotion of the incumbent and in larger interest, public interest, Sri so and so, that is a petitioner, is hereby transferred and posted as Assistant Professor, Department of Orthopedics. My lord, my cadre is being changed so that they don't have to give me the promotion. I appeared in selection process by APSC, appointed in oncology department.
Where is that order?
By my lord.
Where is your appointment order?
Yes, and that is in the writ petition, my lord. Lordship will come to advertisement is at page 29 of the writ petition.
No, we want to see your appointment.
Appointment order at page 30 of the writ petition, 30.
Yes.
I am at serial number 94, page 31. Serial number 94, Dr. Lohit Kolta, appointed as Registrar Oncology, Guwahati Medical College. Pursuant to a due selection process, my lord.
What is your qualification?
My lord, advertisement prescribes, my lord, orthopedics, ENT and all. The advertisement I have annexed, lordship can kindly see at page 29. Page 29 of the writ petition. Oncology is at serial number 27. For registrar, 3 posts were there, and the educational qualifications in column 5. MD Medicine, MD Pediatrics, MD Radiology, MD Radiotherapy, MS Surgery, ENT, MS Orthopedics, and so and so.
And you are qualified as?
I was MS Orthopedics. But I joined as Register Oncology, my lord, and in the year 2009. So until date, I am, my lord, serving as oncology. And at present, I am assistant professor. However, this honorable was directed to give me promotion to the post of associate professor.
Okay.
Yes. Now, my lord, coming to page 32 of the IA.
So you challenged, you approached this court challenging your non-promotion.
Non-promotion in the
in selection.
Yes. In the year 2014, Honorable Court directed. Again, they, my lord, tried to tinker with my promotion. Again, I approached in 2018, which was disposed of on 16/5/2024. That paragraph 22nd, 27, I have just read. However, till then, that order has not been complied with. Instead, on 7th of February 2025, page 32 and except B, they transfer me outside my cadre mile. And this order is still pending, your lordship's order. So, my lord, in this connected writ petition, that is WPC 1.
What was the direction? of the court, it had interfered with the DPC selection.
Yes, yes, para 26 at page 30, my lord. And directed to give me retrospective promotion from 9/9/2014.
No, let us read that paragraph.
Yes, page 30, it's para 26. In view of the above, while impugn action of the review selection board dated so-and-so and consequent order dated so-and-so of the department have been set aside, the respondent authorities are directed to immediately hold another review DPC to consider and promote the petitioner to the rank of associate professor. Such promotion is required to be given effect from 9/9/2014 as directed by this court in the judgment and order dated so-and-so passed in WBC so-and-so. Consequently, all notional benefits, including the seniority and proper fitment, are to be given to the petitioner in the rank of associate professor from the said date of 9/9/2014. And my lord, para 27 will also peruse conduct, my lord, of the department.
All right, then what happened?
So this order was passed on 16th of May 2024. They are still sitting over the matter. On 7th February 2025.
You did not file a contempt?
Yes, contempt is pending, my lord. On 7th of, after filing of the contempt on 7th of February 2025, they passed this my transfer order, transferring me outside my cadre, my lord, at page 32 of the IA. Am I clear, my lord?
Page 32.
Of the IA. From oncology, GMCH to orthopedics, Jorhat Medical College and Hospital. I challenge it in the connecting writ petition. This transfer order has been assailed in the connecting writ petition, my lord. Lordship will kindly turn to
You are transferred as what?
As assistant professor.
And you are holding which post?
Assistant professor.
But your qualification is orthopedics.
Yes, that was while entering into service.
Now, what further qualification have you acquired?
No,
in oncology.
Oncology, my lord, in the writ petition, I have annexed my experience certification. All that has been decided, my lord, in the judgment. I can refer to those paragraphs.
Yes, please, please.
Why this honorable court directed me to grant associate professor? Because of my qualification, that has been decided, my lord. May I read the whole judgment, my lord? Take some.
You show us.
Yes, my lord.
See, your appointment was in oncology.
Yes.
Your qualification is MS in orthopedics.
For entering into service.
Entering into service.
Yes.
You did not have any specialization in oncology at the time of entry.
Yes. Subsequently, I had, my lord.
So at the time of entry into service, you are selected as an orthopedist.
No, as a registered oncology, but requirement was orthopedics.
Your specialization was in orthopedics.
MS orthopedics, correct.
You were selected and posted as registrar oncology.
True, my lord.
Right?
True.
So now you have been sought to be transferred to the Department of Orthopedics.
True, my lord. Which cannot be because I have now, by more than 10 years, I have served in oncology department.
You may have served, but your basic qualification is that of an orthopedics.
Yes, true.
It's not that you are transferred to gynae or maybe community medicine.
That is not the issue. My lord, the direction of this honorable court is to promote me as an associate professor of oncology. Where is that compliance, my lord?
All right. Now,
where is that compliance?
Now, we just want to see what qualification you have acquired as an oncologist.
Yes, my lord. Lordship, from page 6, Annexure 10 to Annexure 14, in fact, my lord, 15 of the writ petition, page 61 to 83, are my lord, qualifications that have been acquired in oncology department.
Page number?
Page number 61 to page 83 of the writ petition. I'm sorry, my lord. Page number 75 to 83, not 61. Page number 75 to 83.
No, this is your experience.
Yes.
We are talking about institutional qualifications.
No, qualification extra, I don't have to acquire, my lord. I have to teach only that. Because I'm an assistant profession now, man. I can show my experience.
Unless you have experience in oncology, how do you consider yourself to be a teacher in oncology?
No, my lord, these are my experience certificates from 75 onwards.
So experience is with regard to the services rendered in the oncology department.
True, my lord.
It merely says that you have been working on so-and-so provided surgical oncology services.
76, 77. And I have done my PhD also.
All right.
PhD lordship, my research papers at page 78. And 83 is my PhD degree.
Okay, now, after interference of
Doctor-
the earlier DPC, there was a direction to hold a fresh DPC for considering
Not considering the positive direction to promote.
to promote.
Yes.
All right. Then
Then
this has not been appealed. There's no appeal against this.
No appeal, contempt pending. Without complying with that, my lord, they transfer me outside my cadre. I challenge the transfer order in this connecting with petition. This honorable court state the transfer order, thus you will find at page 33 of the IA in Excel C.
Yes.
The operative portion is at page 35, the last para. Having regard to the overall facts and circumstances of the case, it is hereby provided that operation of the impugned transfer order dated 7/2/25 shall remain suspended till returnable date. And it has been continued, extended from time to time. So transfer order stayed, my lord. Now, my lord, despite the stay of transfer order, despite there being a positive direction to promote me, nothing has been done. They've stopped my salary, they've stopped my work, my lord. Lordship will kindly see. They've filed an affidavit in opposition to this IA. Lordship will kindly turn to para 9 at page 52 of their counter affidavit, my lord. Page 52. Running page 52, my lord.
Yes.
Para 9, may I read it, madam? That with regards to the statements made in paragraph 14 of the writ petition, the deponent begs to state that consequent to the said interim order, the department awaited compliance from Dr. Kulta in terms of resumption of his official duties in his substantive post at the Oncology Department, State Cancer Institute, GMC. However, as per the report submitted by the Superintendent SCI GMC by their letter dated 7/5/25, it has been categorically stated that Dr. Kolka has not rendered any clinical services or discharged any official duties at SCI GMC since 27/2/2025, the date of stay order, the sub-para, my lord. In view of the above, while the department remains bound by the directions of the Honorable Court, it is respectfully submitted that release of salary for the period subsequent to 27/2/2025 is difficult to justify, as no service has been rendered at the place of posting by the officer concerned. Now, my lord, pursuant to this stand, we have filed an additional affidavit, my lord. Lordship will kindly turn to page 125, running page of our affidavit, and excerpt G. Running page 125. This is the letter that has been referred to. With reference to the subject under reference cited above, this is to inform you that as per the High Court stay order dated so-and-so, Sri so-and-so, Assistant Professor Ankos, they have not rendered any kind of clinical services or discharged any kind of official duties as SCI GMC with effect from so-and-so. Lordship will kindly see the very next page. Is it not contemptuous, my lord? Very next page, at page 126. On one hand, they are saying I am not rendering any duty. On the other hand, they themselves had, my lord, directed not to allot any official work to me, my lord. Page 126, Annexure H. In pursuant to order dated 7/2/2025, Dr. Lohit Kolita, Assistant Professor Oncology, has been transferred to the Department of Orthopedics. And this is on 14th of May 2025, Jorhat so. Subsequently, he was released from SCI GMC by order number so from all official duties at SCI GMC. Therefore, in the above context, it is hereby directed to all the faculty stroke staff of this institute not to allot any official duties or entertain any matters handling over any official documents without the consent of the other side. On one hand, they say, my lord, I am not working. And on the other hand, they have directed not to allot any official work to me. That's why there being a stay order. First, you don't promote me, you are addressing me as assistant professor. There being a order holding the field from this honorable court. Then you say you don't get salary because you are not working. However, their own document says that they have directed not to allot any work. And to substantiate my claim, I am saying that there are punching machines, my lord. I am regularly attending. I have made a categorical statement in this additional affidavit. I am punching them, my lord, attending. And also will kindly turn to page 134, another to counter their allegation of not working. Page 134, my lord. So, my lord, this is a duty register published by the department, that is GMCH. Until further order, resident doctors, consultants, so to follow duty register would be effective from 1st of February 25. So this is prior to the stay order. And down below in the second table, my name appears at serial number 3, my lord. In the second table, Dr. L. Kolita, has your lordship got it? Sorry, my lord, serial number 1, second, Dr. L. Kolita. After Professor N. Mohanto, Dr. L. Kolita. This is effective from 1 February 2025, that is prior to the stay order. The very next page, another duty roster, here my name goes missing, my lord. This is effective from 1st of March 2025. Petitioner's name is not there, though there is a stay order, my lord. Again, similarly at page 136, petitioner's name is missing, though there is a stay order.
Yes.
Yes, at page 137, this was issued on 29/6/24, with approval from the director and until further order and assigning any region thereof, the following is the division units for the surgical oncology department with immediate effect. So under unit 2, my name appears at serial number, the second column. However, they have revised it on 5th of May 2025. Petitioner's name is missing.
Yes, Mr.
So let them show a duty register where my name appears, my lord.
Yes.
It is a conduct, my lord.
First of all, my lord, one statement has been made by the very beginning of the argument that my lord, the present writ petition has been preferred, being aggrieved with the action of the respondent authorities in not promoting the petitioner pursuant to the earlier order passed in the earlier writ petition. The lordship will see page 24 of the writ petition. What is the prayer made, my lord? As I have stated, my lord, whether it is an impugned transfer order which is under challenge here, or that, my lord, promotion is the issue in the present writ petition.
Page 24.
24. The prayer starts.
24 of the
writ petition, my lord. Lordship will see 25, the relevant part of the prayer. 3 prayers are there. 4.
Yes.
A, certiorari shall not be issued to set aside and quash the impugned transfer notification dated 7/2/2025. B, mandamus should not be issued directing the official respondents to recall, cancel the impugned transfer order dated 7/2/2025. C, mandamus directing the respondents to show cause as to why exemplary cost may not be imposed upon them for trying to victimize the petitioner again and again for approaching this honorable court and getting a favorable order for promotion to the next higher post. Third is the D is the interim prayer. So where is that, my lord, prayer to say that, my lord, that he wants a promotion? This entirely, my lord, writ petition is based on the, my lord, transfer order. So let me place, my lord, in our affidavit the ground for the transfer.
No, first thing, there is an earlier proceeding where there is a direction that he
My
should
lord.
be promoted to the next.
Lordship.
admittedly, no appeal has been filed.
My lord, that part we are not disputing, my lord.
Right. Now some transfer order is there.
Yes.
The court has passed an order staying the transfer order.
My lord.
You have not
That is
filed,
the present.
you have
situation.
not filed an appeal against that order granting interim
Stay.
protection.
Yes, ma'am, no issues, my lord.
So therefore, the question today would be, why are you not releasing his salary?
But today, my lord, that part also I will address. My lordship, this matter has been fixed for admission in today. My lord, transfer order from February to my lord, now in July is still pending, my lord. We have pleadings are over. Lordship will decide the entire issue.
We may
I will
decide
address on that.
today, we may decide it after 3 weeks, but give us a reason why the salary has not been released. He is still an employee.
No, that's why I'm saying, let me start with the impugn order. I will address everything, my lord. Entire issue. That is a part of the writ petition now in the IA, my lord, that whether salary he must get or not. But why we are not giving the salary. My lord, let me address on the, my lord, impugn transfer order, why it has been issued first.
Yes.
Then I will go to that aspect.
Yes.
Lordship will see the affidavit. But before that, my lord, just one or two documents in the writ petition I would like to point out. Petitioner has referred to the, my lord, appointment letter at page 30. Lordship has already seen his qualification as per the advertisement. It is only orthopedics and MD in orthopedics. That is his qualification. MS in orthopedics.
Yes.
Now, Lordship will see page 30. This is the, my lord, appointment order dated 17 July 2009. Lordship will see the headings, my lord, at the very beginning. Name of the doctor, permanent address, present address, name of the post or department, place of posting. Lordship will kindly mark this place of posting, which is missing in this particular because of, my lord, this Xerox, my lord. Serial number 94 is the name of the writ petitioner. At the end of the, my lord, particular row, Lordship will see the place of posting is GMC Guwahati Medical College. Now in the next page, page 33, Lordship will see this is a promotion order of the writ petitioner which he got in 2011. He has been promoted from the post of Registrar of Oncology Department, Guwahati Medical College and Hospital, promoted to the next higher post of Associate Professor of Oncology Department, Assistant Professor of Oncology Department, posted at Guwahati Medical College and Hospital. So he is an employee of the, my lord, presently also under the GMC. That I want to establish. Now, Lordship will see the affidavit that the department has filed in this regard, justifying the transfer.
Where is the transfer order?
My lord will, I will main writ petition only. Transfer order, Lordship will find
In the writ petition, it is at page 85.
85. Hold on. Fine. 85.
Yes.
My lord, at the time when the writ petitioner was appointed in the Department of Oncology, he was posted in the State Cancer Institute. It was an institution which was running along with the GMC. And the principal of GMC was the main authority, my lord, DDO, the drawing and disbursing officer of the writ petitioner. So all along he has been considered to be an employee of the GMCS. The Lordship will see. Pending receipt of the report of the expert committee constituted to facilitate compliance of the order of the Honorable Guwahati High Court in so and so for holding the review of DPC for promotion of the incumbent and in larger public interest. So the so and so attest to the Lordship will mark the word attest to the State Cancer Institute GMCS is hereby transferred and posted as Assistant Professor, Department of Orthopedics, Jorhat Medical College and Hospital in place of so and so, Assistant Professor, Department of Orthopedics, so and so. But this is the transfer order. It says, my lord, he was working on attachment in, my lord, State Cancer Institute. Now, my lord, in the official capacity, whatever he was holding, he has been transferred to Jorhat.
Now this has been stayed.
This has been stayed, my lord. The main contention of the petitioner was he was a registrar of oncology and later on, my lord, assistant professor of oncology. Here, the nomenclature of the post has been changed. And according to the petitioner, since he is working in the State Cancer Institute, he cannot be transferred out of that particular institute. Whereas, my lord, from the appointment letter, as well as, my lord, the earlier promotion order, as well as this particular, my lord, order, it is very clear that he is an employee of the GMCS, my lord, Guwahati Medical College and Hospital.
Yes.
Now, my lord, also he raised the issue that moment he is transferred to Jorhat, his seniority will go. This will affect the, my lord, that promotion, which, my lord, we are supposed to, my lord, consider as per the Honorable Court's order. In the affidavit, we have clarified that, my lord, seniority of the writ petitioner will not be affected. His status, my lord, as a assistant professor will not be affected. Since he is working, my lord, his qualification as lordship has posed, my lord, he is a MS orthopedics. He has been posted in the orthopedics department.
Oh, I understand
Yes,
everything.
now, my lord, the
Right,
reason
is
for
that the
transfer.
Transfer order is stayed. Present date it is stayed.
Of course, my lord, interim is there. So today, lordship
stayed.
will see the reason for transfer and decide, my lord, whether the transfer order is
We
bad or
decide, we don't decide is a different issue, but it is stayed with effect from which date?
from the date of the transfer order, my lord.
When was the interim order passed?
27 to 2025.
27 to.
My lord.
So why have you not released the salary?
So that's why I'm saying, my lord, may I first address this part, my lord, then I will satisfy that part also, my lord. Because it can be traced out, my lord, entire issue can be traced out. That's why I'm saying, my lord.
No, entire issue threshed out or not is a different issue.
My lord,
But we are asking you a very simple, straightforward question that
lordship.
he is an employee, he has been transferred. Why are you withholding his salary?
Lordship may have a look at the affidavit that we have filed in the IA in that case. IA affidavit. My lord, that's in the additional affidavit that we have filed.
Yes.
Or lordship will see page 52, my lord, running page 52 of the first affidavit that we have preferred in the IA. Correct.
In the writ petition?
No, my lord, in the IA. You
Yeah.
will find it in the IA. Because the non-payment is the issue in the IA. 52 para 9 we have stated.
Yes.
Lordship will see, my lord, in the next page, 53. Lordship will, may I read the, my lord, para 9. The opponent makes to state that consequent to the said interim order, the department has awaited compliance from Dr. Kalita in terms of, there is a writ petitioner, in terms of resumption of his official duties in his substantive post at the Oncology Department, State Cancer Institute, GMC. However, as per the report submitted by the Superintendent, State Cancer Institute, GMC, by letter dated 7/5/2025, it has been categorically stated that Dr. Kalita has not rendered any clinical services or discharged any official duties of State Cancer Institute, GMCS, since 27/2/2025, the date of stay order. There is a report that the government had, my lord, accordingly we have placed it before this honorable court in the affidavit filed in the IA.
He is not rendered because you have not given him a duty roster.
No, that's why those documents were placed in the additional affidavit filed in the IA. We have replied to that also, my lord. Because an additional affidavit was preferred. My lord, here page 147 in the IA, my lord, that once 147.
Yes.
My lord, para 5. First paragraph is same, my lord, as that I have read in the earlier affidavit. Below, my lord, in view of the above, while the department remains bound by the direction of the honorable court, it is respectfully submitted that release of salary for the period subsequent to so and so is difficult to justify as no service has been rendered at the place of posting by the concerned officer.
Place of posting can't be there because it is stayed.
And my lord, 7, my lord, may I submit, my lord? One document was placed there, my lord, the superintendent has specifically issued a letter not to give any official duty to the petitioner. Lordship will see para 7, my lord. The opponent begs to submit that the notification was issued inadvertently and withdrawn by notice dated 3/6/2025 in compliance of the Honorable Court's interim order dated. So it was immediately withdrawn. When it came to the notice of the government, he was instructed that it should be withdrawn because that interim order, my lord, is operating. Question of issue, my then lordship.
So as on date, what is his status? Is he presenting himself for duty? Is he allowed to?
My lord, yes, my lord. Regarding that, my lord, he has not even approached the superintendent, my lord, in this regard. He has submitted that he has given his biometrics. My lord, once he has given the biometrics, it must be available in the institution. You will have to approach, my lord, that yes, I am present. Why you are not giving me that in the duty roster? Nothing was done, my lord. He remained silent, my lord, for all along for 2-3 months. Thereafter, this I was filed. At least he should have. He has given the biometrics. Even, my lord, that they
Pursuant to the transfer order, was he released from service?
No, no,
was he released?
that's why I was pointing out to the affidavit in opposition. There is a notification, official notification of the government of Assam that moment the transfer order is issued, there is no formalities required to be given that my lord handing over, taking over charge. Moment the order is issued, you are released. That we have annexed in the writ petition. There is a OM, my lord.
Where is
It is applicable to all.
Where is it?
Well, it's a page 200 of that IA bunch. So this is applicable to all. My lord, in the IA, my lord, that notification has been annexed. OM has been annexed. It's 25th of November 2024.
Page 200.
200, my lord. It is
Page
dated.
200 is withdrawal of some notification.
Then, my lord, there's some, my lord, issue in the page.
201.
Will be, my lord, dated 25th November. Yes.
25th
Yeah.
November, yes. 201.
May I read?
Yes.
It is a well-established part of service law jurisprudence that transfer is an exigency of service. Under the terms and conditions of service, an official has no right to remain absent or refuse to join in the new place of posting upon transfer. It is reiterated that all transfers and postings must be given effect by an official under order of transfer without any delay, and such an official should hand over charge immediately. Any representation submitted by the concerned official against the transfer order will be entered in only after he or she joined in a new place of posting. If the transferred official fails to join in the new place of posting timely, strict disciplinary action will be initiated against the official. Further, it is observed that some official under order of transfer take the plea of not being released by the controlling or reporting officer as the ground for not handing over charge. However, there is no provision in any rule for issue of release order by any authority subordinate to the authority which has issued the order of transfer. Therefore, the practice of issue of release order consequent to issue of a transfer order is henceforth barred. No official needs to wait for a release order to hand over charge once an order of transfer is issued. If an official does not hand over charge on his own promptly, the official shall stand released automatically. So this has been issued by the government.
What happened to your FRNSR rules?
Malak?
Assam FRSR
Lordship.
rules? You say there is no rule for issuance of release. Does it stand amended?
That part, my lord, nobody has raised that issue.
Secondly, perhaps what is being sought to be conveyed is once a transfer order is issued, you can't wait and say that you have not been released. So you must promptly take the matter, get your release order, get your release order and leave.
Yes, immediately. It's not that you will be waiting, my lord, after you will take leave, then you will wait for another week.
Here there is a stay order. The transfer order has been stayed.
My lord.
So there is no question of issuance of a release order or anything like that.
No, I am not saying about that, my lord. What my submission was that, my lord, he has got a transfer order. He is aware of that. He is now to work in the, my lord, same place of posting, at least till the disposal of the writ petition, whatever be the issue, my lord, the outcome. So he ought to have been there, my lord, before his higher authority.
There
superintendent.
has to be a
said-
report to say that in spite of the stay, he is not reporting for duty. Is there a statement there in the affidavit somewhere? In spite of he is enjoying a stay order, he is not even reporting for duty. So therefore, no salary.
No, my lord,
And the duty rosters, they have not disputed, my.
no, duty roster, he is now pointing out into July or June, my lord. Why at that point in time, he did not hesitate that why my name is not there despite being a, my lord, stay order. That's the whole issue. He gives it, my lord, the biometrics and he leaves to, my lord, his home from the office.
You show us if there is anything there.
Because there is not a single, my lord, document to show that he has
But
given some
whether
restrictions.
he is reported for duty or not reported for duty, fact is that the transfer order is stayed, he is entitled to be released his salary.
No, my lord.
If you want to take.
Otherwise also, my lord, in a general issue, my lord, say, my lord, a petitioner is working, you will have to report for duty daily, my lord.
If he doesn't report, you are within your rights to proceed against him. Have you initiated any proceedings
My
against
lord,
him?
because of the pendency of this particular litigation.
This interim order doesn't prevent you from taking up proceedings if he behaves in that manner.
But if that again, please, second, he will come up rushing to the court stating that, my lord, vindictively, now again, we have issued a SOGO for this. It will be stayed, otherwise we know the.
The courts are meant for the citizens. We can't stop them from coming to
I
court.
understand, my lord.
But fact remains that there is an interim order and his salary ought to have been released. This is you are in the zone of being treated.
No, that of course, my
that
lord,
you are
these are-
showing
my
contempt
lord,
to the
admittedly, this is a ground, my lord. Otherwise, my lord, finally, what your losses come, my lord, submit order, my lord, that will have to follow. But my lord, going by the additional affidavit, yes.
You first release his salary for whatever period he has worked.
Oh, yes, for
Whatever period he has worked, you release his salary.
Fine.
Or you show us that there is some report that he is not reported in spite of allotment of duty, he has refused to work.
No, my lord,
And you want
regarding
to take
that,
up proceedings.
lordship, he has referred to certain documents regarding the duty part, duty charts and all. Lordship,
that
see
you
page
said you-
134, it is dated January 2025. Order came in, my lord, February.
See,
Then again, 27 to 25.
the officer who's in charge of that particular institute is aware who's on duty, who's not on duty. Has the officer raised any issue before the higher authorities that this man is
Even
not
that, my lord,
available?
may I place the dates? Just, my lord, the page 134 of the IML. Part of the IML, the additional affidavit preferred by the petitioner, where he wants to show that, my lord, his name is not there in the duty chart.
Yes.
I do this. Lordship will say page 134, date of the duty chart.
His name is not there. He must have been very happy, hoping that he'll get his
No,
salary.
my lord, this is prior to the transfer order. That's what I'm saying, my lord.
In this letter, my name is there.
134.
134, second table, my lord, first serial number 1 after N. Mohanta, Dr. L.
It is
Kolkata.
there. It is there.
That is what I'm
No,
pointing.
let me, my lord, clarify why I'm pointing out. Lordship will say that's why down below, serial number 1. In the first chart, my lord, his name is not there. He's a senior consultant. My lordship will see serial number 1. It says, my lord, consultant on call duty. On Saturdays and Sundays, lordship will see, my lord, all. So they will have to be there, my lord, on the.
On Monday and second Saturday.
Yes.
You are my employee.
So, if any emergency arises, this chart is there that they can be called or they can be consulted over phone also, my lord. But, my lord, from serial number 1 to 40, not there.
Not there, but this is issued by your superintendent.
No, I understand, my lord. That is the procedure that I'm saying. I want to point out. They are seniors, my lord. They need not be
Available 24/7.
Yes.
And this is with effect from, let's kindly note that.
So therefore, if he is senior, then he need not.
But he will have to be there for duty, my lord.
He'll
But
be there.
again, my lord,
allot him a duty.
137 again, my lord, it's of June, my lord, 24. That cannot be relied upon in this case.
Why? What about 135?
We are closing this IA. You give him his salary.
For the period he has worked.
Whatever he has worked with effect from the date of interim order. Heard. Mr. J.
But my lord,
Patwari.
main lead petition may be hard because my transfer order is
We
pending.
hear it. We are not saying that. We are troubled by the fact that in spite of in a stay order of the transfer, you refusing to release his salary.
First, they have to pass with the content.
No, that plea cannot be, what is the question of purging with the contempt to comply with the transfer order?
Their
How can that
exception-
be a ground, my lord?
You follow it up before the contempt court.
Yes, that cannot be a ground in the transfer order. We'll have to.
No, the
Consider
contempt
the
petition is
ground for
already
transfer.
pending. What I am submitting for your lordship's consideration is, if their action amounts to my lord contempt, sir.
We have already filed a contempt. You proceed with that matter.
Yes,
We are
sir,
not
we are
handling,
proceeding.
we are not taking up your contempt
Yes, yes, my lordship.
petition. See, you are a qualified medical professional,
Too much.
right? I would like to believe, subject to such objections not coming from the bar, the lawyers and doctors are one category. We don't restrain themselves in specialities. You define your own speciality as per your choice. But you are qualified to do anything as an orthopedic. You are working as an oncologist. You refuse to go to the orthopedics department. Why?
But that department has now been abolished. I would have placed it, my lord, with the final hearing.
Your very purpose is to serve the society.
True, my lord. But they have to comply with the orders first, my lord, not like this, my lord.
You are behaving as if you are a bureaucrat.
No, lordship.
That you are being transferred from place X to place Y. There is an interim order. You will not report for duty.
No, not like that. Lordship will kindly see the attending factions around. From to last.
Therefore,
day-
we are passing an order directing them to release your salary.
Yes, last
But
10 years.
please be aware of the fact that you are a doctor and you are required to offer services to the
Yes,
society.
I am aware of that. But for the last 10 years, I have been litigating, my lord, and this is the way they are treating, my lord. I was entitled to promotion in the year 2014, not 2024.
That we look into it. Heard Mr. J. Patwari, learned counsel for the applicant petitioner. This is in IA 1462 of 2025. This IA has been filed, praying for a direction to the respondent authority to release his praying for, what is the charge sheet?
Two, my lord.
What is the charge sheet?
My lord, during the pendency, my lord, search sheet has also been issued, my lord, against that. That's the difference.
Is it under challenge?
Yes, in WPC 418, lordship on the other day.
No, not in the present petition, my lord.
This IA is filed where?
I is filed in this petition.
Is it under challenge?
Yes, because they have.
Is it under challenge in WPC 1089? 84?
No, in this petition, it is not under challenge. It was subsequent to filing of this.
So the petition is in file. IA has been filed with the following prayers, the word 1, 2, 3, 4. 1, 2, 3, 4. Stop. The petitioner is shorn of unnecessary details. The basic facts relevant for the disposal of the IA is that the petitioner is employed as a medical professional under the state, what is a state cancer
institute?
State Cancer Institute.
As an assistant professor, oncology.
Well,
Stop. The petitioner was appointed by. Where is your appointment order?
Yes, a notification in page
31.
Of IA.
Of the
Writ petition. He was appointed as
17/7/19, 9, 17/7/9.
2009. Page 30, 30 of the
was
receipt.
appointed on 17/7/2009 by process of selection and appointed as registrar oncology and posted as Guwahati Medical College Hospital, Guwahati. Stop. It is the claim of the petitioner that since then he has been rendering his services to the satisfaction of all concerned. He has attained, by dint of his service, he has attained exposure and qualification and specialization in the field of oncology. Stop. Petitioner claims that he ought to have been considered and promoted to the post of subsequent thereto, he was promoted to the post of assistant registrar.
Assistant professor.
Assistant professor.
Oncology.
While he was rendering services in the post of assistant professor, the department undertook a selection process for promotion of eligible candidates to the next higher post of associate professor.
In the year 2014.
Is it associate professor or associate professor oncology?
Associate professor oncology.
Department will be, my lord, that we will decide, my lord, because now as on that, my lord, the department is not.
Associate professor in various departments, including oncology. Stop. The petitioner was not selected by the, was not recommended for promotion by the Departmental Promotion Committee. And thereafter, he approached this court by filing WPC number 2858 of 2018, challenging his non-selection and praying for appropriate orders. So this matter came to be disposed of by judgment dated 16/5/2024, whereby this court set aside the review selection held on 2/4/2018 and the consequential order passed, and the respondent authorities were directed to immediately hold another review DPC to consider and promote the petitioner to the rank of associate professor. The coordinate bench further directed that such promotion is required to be given effect from 9/9/2014 as directed by the court in a still earlier judgment and order dated 19/8/2016 passed in WPC 1395 of 2015. Stop. All notional benefits, including seniority and proper fitment, were directed to be given to the petitioner in the rank of associate professor with effect from 9/9/2014. Stop. Since this order was not complied with, the petitioner filed the contempt petition, being contempt case number
170 of 2024.
170 of 2020. Stop. It is the claim of the petitioner that while the petitioner was that the department, besides not complying with the directions contained in the judgment and order dated so-and-so, passed in WPC so-and-so, the department issued the transfer order. Where is your transfer order?
Page 32 of the I.
32 of the I.
Yes.
Issued the transfer order dated
7/2/2025. Page 32, Annex B.
7/2/2025, whereby the petitioner, who was shown to be an associate professor, Department of Oncology, Guwahati Medical College, attached to the State Cancer Institute, GMC, was transferred and posted as assistant professor, Department of Orthopedics, Jorhat Medical College and Hospital, Jorhat. Stop. This order is assailed by filing WPC 1084 of 2025. Stop. The applicant, the petitioner, before the writ court, projected the case that this impugned transfer order could not have been issued. Firstly, on the ground that the earlier direction of the court by judgment and order dated so-and-so, passed in WPC so-and-so, earlier specific direction issued by the coordinate bench by the judgment and order dated so-and-so, passed in WPC so-and-so, was not implemented and no review DPC was held, promoting the petitioner to the post of associate professor as directed. And further, now the petitioner is sought to be transferred out of his cadre and posted in a different cadre in Jorhat Medical College and Hospital. So it is the case projected by the petitioner that he was appointed as Registrar Oncology in the Guwahati Medical College Hospital, and the directions of the coordinate bench in WPC number so-and-so was to give, direction to the respondents was to pass orders for promotion of the writ petitioner to the post of associate professor during his considering his services rendered in the Department of Oncology. However, by the impugned transfer order, he has been sought to be transferred out of the Department of Oncology and posted in Department of Orthopedics, that too in Jorhat Medical College. So, under such circumstances, this impugned transfer order came to be assailed. So, this court by, where is the interim order?
Page 33 of the IMA.
By an order dated
27 to
coordinate bench by an order dated 27/2/2025, while issuing notice, stayed the impugned order of transfer. Stop. The said writ petition is still pending. The present IA has been filed on the ground that, notwithstanding the transfer order, notwithstanding the stay of the transfer order, the writ petitioner has not been allowed to work in his present place of posting, and his name was, and no duty has been allotted to him, and his salary with effect from the date of transfer, which is 7/2/2025, has not been released. Under such circumstances, this present IA has been filed. Mr. B. Gowal and that line already. Under such circumstances, this IA has been filed. He prays that the IA should be allowed and directions be issued for release of his salary. So, Mr. B. Gowal, learned additional AG appearing for the state, strongly disputes the contentions raised by the writ petitioner. He submits that
There are certain issues of misconduct because of which manner the petitioner has been transferred. That is the ground for transfer we have stated. That may be recorded. Only
that there were certain issues, there were certain instances of misconduct.
Yes,
and because of which the petitioner has been transferred out. And it is an incorrect submission made by the counsel for the petitioner that he's been transferred out of his cadre. The petitioner is qualified in orthopedics and was recruited as a registrar by his initial order of appointment, and he was placed in the Department of Oncology. And since then, he's been rendering his services
under GMCH.
Stop. Therefore, as per the requirement of the in public service and as per the decision taken by the authorities, he was transferred and posted in the Department of Orthopedics, yes, in which the petitioner holds qualifications to serve as such. Stop. Therefore, it is not a case that the petitioner has been transferred to a lower grade or a lower post, or in a post where the petitioner is not qualified to hold these services. Stop. Insofar as non-release of his salary, it is submitted that the petitioner himself did not report for duty.
Yes,
and consequently, the authorities in the State Cancer Institute had no option and could not allot any duty roster to the petitioner, and therefore his salary was not released. Counsel for the parties have been heard. The pleadings available on the IE as well as pleadings available in the IE has been finished. So there is no dispute at the bar that the impugned transfer order dated so and so 7/2/2025, which is assailed in WPC number so and so, has been stayed. Stop. No appeal has been filed. The interim order staying the transfer order was an inter-party order passed by the court. No further appeal has been filed by the respondents. Stop. As on date, the interim order dated so and so, staying the transfer order dated so and so still subsists. So the effect of the interim order is that the petitioners will continue to serve in his present place of posting prior to transfer, which is Department of Oncology, attached to State Cancer what?
Institute.
Under GMCH. Stop. Under such circumstances, the respondents are duty bound to release his salary as found payable unless the respondents initiate any proceedings under the provisions of law and as permitted by law. So, the question whether the petitioner rendered his services in spite of the interim order cannot be decided at this stage because in the pleadings there is no material to suggest that the petitioner did not report for duty or refused to perform any duty allotted to him. On the contrary, in the IA, there are some orders which are pointed out issued by the superintendent of the State Cancer Institute, where it was instructed not to allot any duty to the petitioner. Stop. This order, however, came to be withdrawn subsequently by passing appropriate orders. Stop. Considering the fact that the petitioner is still rendering his services in the place of posting, which is Associate Professor Oncology in the State Cancer Institute under the GMCH, and the interim order still subsists, and the writ petition is also pending disposal. This court directs the respondents to release the salary to the writ petitioner with effect from the date it was stopped, which is 7 February.
7th of February.
7 February 2020. You did not receive salary for February, or you did not receive from 7th?
From 7th. January month I have received.
From the stay order, it will be from the stay order.
Because same thing, February.
From 7 to 2025. Stop. Petitioner will, on the other hand, the petitioner will also report for duty before the State Cancer Institute and will perform any duty as allotted to him. And the authorities will continue to release his salary during the subsistence of the interim order passed, or such other orders have been passed by the court. So, since no challenge is made to the disciplinary proceedings initiated against the writ petitioner in WPC 1084, the prayer made in the IA with regard to, in respect of the in respect of stay of the operation of the charge sheet number so and so dated 24/4/2025 is rejected. Stop. It is open to the writ petitioner to approach this court by filing appropriate proceeding.
Already notice has been issued.
No, even then,
But IA accordingly stands allowed, disposed of in terms of the above, writ petition be listed for
on 7th August.
hearing.
On 7th of August, the Thursday.
7th of August.
Very short issue on that manner of disciplinary ground. Issue the transfer order.
14th August. Well, list on 14th August.
Can I make
Deep
it?
level.
Yeah, Well, item number 21, I have some problem at 2 PM, Can I have it any other day,
21.
21, And showing the name of Mr. Nadine.
We are not made party.
Party, he was not party.
Not made party.
Let it be taken over.
Next week.
Next
Come up
week.
next week. We'll come back at 2.
Timing again 7.
One more thing, your lordship. As per what my instructions have come, that in the portal, in the website, since he applied for both the posts, he was shown to be qualified for both. That advertisement is not, he was supposed to.
No, just go. Lordship, I have received the advertisement, Lordship. Just now, Lordship. Lordship, there are 4 advertisements issued by each of the directorate, Lordship, and he applied for 2 advertisements. That can be seen from his application, Lordship. Lordship, I'm extremely sorry, Lordship. The front is extremely, Lordship, small, Lordship. But just now I have got the instruction, Lordship. So the electrician post is at serial number 6, Lordship. And
We'll rely on your
Lordship,
understanding of what is
and
there.
Lordship,
because
the
it's too small.
qualification is HSLC passed with diploma in electrical from government ITI or from any government recognized institute. So Lordship, he had the qualification of an electrician, Lordship. And Lordship, he also applied for that post, Lordship, in from page 18, Lordship.
No, the question is you selected him as a blacksmith. Then you allowed him to
Lordship,
work
Lordship,
as a electrician.
Lordship, he has applied. He had the knowledge that he has only the qualification for an electrician, Lordship, because the advertisement was.
Whatever it may be, you selected him
But he
through a
does.
process of recruitment.
Yes, Lordship, but he doesn't have the qualification.
So you just throw him out like that. Where is the provision?
Lordship, I'll come to my stand, Lordship, in my affidavit, Lordship, but Lordship may have a look at page 18 of the writ petition, Lordship. Here, Lordship, Annexure C, Lordship, page 18, Lordship.
How many years has he worked?
Lordship, for 2 or 3 months.
3.5
Years?
months.
3 months.
3 months.
Yes, Lordship.
3.5 months.
Page numbers?
18, Lordship.
18.
Lordship, this is a application, Lordship. Lordship, here, Lordship, he applied for the department DME, Lordship, grade 3 technical. And there is specific, Lordship, direction, like Lordship request, do you want to apply for the department DME? He has opted for yes, yes. Do you want to apply for non-technical? Yes. Post of DME technical grade 3 blacksmith, he himself choose, Lordship, all this. And Lordship, post of DME non-technical museum keeper, Lordship. But he doesn't have any qualification in this department, Lordship, for this department DME. Lordship, again, Lordship, down below, Lordship, second thereafter, Lordship, Department of DHS, Lordship. There also he applied for the grade 3 technical post electrician and non-technical, Lordship, basic health worker BWH. But for the other two department, Lordship, Directorate of Health Services FW, he did not apply. And for Department of Ayush, Lordship, he did not apply, Lordship. So, Lordship, he was having the knowledge that he doesn't have the requisite qualification, Lordship. Even though, Lordship, he had the qualification for the DHS, but he applied for DME as well. Lordship, it is his mistake, Lordship. He has opted, he should have straight away said no, Lordship.
Did he appear in the selection process?
Yes, Lordship.
For both.
What for
For both.
What is that selection process where you could not find out that he was not qualified? And you are now saddling him with the
Lordship,
responsibility.
once we have come to know, Lordship, that he doesn't have the requisite
How
qualification.
did you come to know?
Lordship, after Lordship asking him for document verification, Lordship.
After appointing him?
Yes, Lordship. Because
No, no,
Document
document
verification is
verification was
after.
prior
no,
to
no,
that.
priorly it was done, Lordship, but it was an oversight, Lordship. So, Lordship, whenever
If it is an oversight, it is oversight. You have to give him a notice. He is entitled to a notice for whatever it is worth.
Lordship, even though, Lordship, the notice is served upon him, Lordship, he cannot have the requisite qualification, Lordship. Let
We
him
don't
prove,
know.
Lordship.
What
he
is
has-
your procedure for removal from service? Do you
Lordship,
have any rules?
Yes, Lordship. Lordship, my stand, Lordship, in the affidavit is that he doesn't have the requisite qualification.
I am asking you a pointed query. Kindly give a reply. Or you agree, according to you, doesn't have a qualification, all right, but how do you propose to remove him? This is not at
Lordship,
the
it is
stage
there
of-
in the,
This
Lordship,
is
my
not prior
affidavit,
to,
Lordship.
this is not prior to his appointment that you found out that he did not possess the qualification. You gave him an appointment.
Yes, Lordship,
You allowed him to work.
Lordship, there, that stand has been taken, Lordship, in my affidavit, Lordship. Lordship, at page 61, Lordship. Lordship, it starts from page 60, Lordship. May I read, Lordship, paragraph 6, Lordship? Page 60, Lordship, para 6. That the answering deponent begs to state that the aforesaid order was issued in accordance with the resolution adopted by the Recruitment Committee on 21/8/2023, which mandated cancellations of appointments of candidates found ineligible as per the original recruitment advertisement. Further, as per advertisement, no number so and so, the essential qualification for the post of
Is
black.
it your case that he projected himself to be a person qualified in the post he was appointed by suppressing some documents or by attempting to mislead?
Lordship, our stand is that no notice was served upon the petitioner prior to issuance of termination order as per the terms and conditions of the service of the petitioner, Lordship.
Where is the terms and conditions?
Lordship, at page 27, Lordship. Lordship, the terms are right down in the, Lordship, in my copy, Lordship, the terms are not fully stated, Lordship.
No, no, terms are there, your lordship, at page 27, it has been stated. Stated while on the deputation or on a test, whatever it is, he shall continue to be guided by the Assam Civil Service conductor. So it is there.
Lordship, in my copy, Lordship, point 4 is not there.
How is it?
It's not there.
What are you?
Lordship,
Yes.
the terms and conditions are not there in my petition, Lordship. Point number 4 is also not there, Lordship. Lordship, copy, Lordship.
Page number 27.
Lordship, yes. 1, 2, 3 is there and 5, Lordship. I'm sorry, Lordship. Lordship, copy might be there, Lordship. Lordship, copy. Terms and conditions.
This page 27 is a part of the writ petition.
Yes,
Yes,
Lordship,
it's a part-
but it is not entirely, the terms and conditions are not entirely there, Lordship.
In your affidavit,
No, Lordship, I have not annexed, Lordship.
No, the terms and conditions is page 27. The following are terms and conditions of service of the appointee. At the first,
Is
serial
there a-
number one itself, it has been stated
what?
We do not.
that he shall be continued to be guided by the Assam Civil Service Conduct Rules, 1965. Assam Service Discipline and Appeal Rules, 1965.
Do you have the original of this with you?
Original to Assam. Yeah. It, yeah, so it-
There's one serial number missing, so we don't know whether.
That is missing, in fact, in this petition also. But
Therefore-
one is there, one is there.
No, therefore we want to know whether
Yes,
it
that
is like that or
original to Assam.
there was a serial number 4 which is not here.
Now, this photocopy which I have also has the same reflection. And one more thing, your lordship, even if that judgment which I relied on, Kamal and Mishra, in that case, even if there is somebody has signed the terms and conditions, even then, your lordship, he has given consent to the terms and conditions. If the terms and conditions have otherwise than this, then also 311 applies. That is what it says. Anyways, that is a separate part. Now, only thing is, lordship, he was shown to be qualified in the portal, for both the posts. And in fact, he was interviewed for both the posts, not one post. That is there in the page 18, that he was called for interview for both the posts.
Lordship, the terms and conditions are necessary, Lordship.
You produce it on
Lordship,
Tuesday.
I'll produce, Lordship.
On Tuesday.
Yes.
We'll pass orders on Tuesday. Matter be listed on Tuesday. Or things for this. Permission, nothing. Yes,
No, you have to.
Yes. We'll pass orders on Tuesday.
Oblige, Lordship.
On 5th.
Much obliged.
Oblige.
Right, council, list on Tuesday.
Typing item 13.
My lord, Mr. Arcade Dapsudri in Lakes in court number 3, my lord, in hearing matter. May I pray this matter may day after tomorrow, my lord?
Next week.
My lord, may I pray for fixed date, my lord?
Next week.
Or on 6th or 7th, my lord. Interim, my lord.
7th.
7th.
Interim order.
Interim may continue, my lord.
Interim order passed earlier, we continue.
Oblige.
7th. On a request made by, on behalf of Mr. R.K. Chaudhary. Learned DSG.
Oblige, Lordship.
Item 23.
My lord, this maybe perhaps sent to mediation, we're making an endeavor, my lord, because
Right.
it's addressed to
Letter be sent for mediation. As both parties agree. Based on 22nd only.
22nd, my lord. I will
August.
inform.
Right, 36 tomorrow, so.
Item 26.
You agree for appointments?
I seek the appointment.
Huh?
I seek the appointment of the arbitrator.
Of the arbitrator.
Yes.
And
And he is
respondents?
objecting. I am objecting.
Who, have you named the arbitrator here?
No,
Who has filed the petition?
I have filed.
So they have not agreed to the arbitrator appointed by you.
Yes.
So we'll appoint an arbitrator.
My lord, there are some elements of fraud.
Let the arbitrator decide all that.
Yes.
My lord, there is a judgment of the Supreme Court which says, my lord, that if there is some elements of fraud which cannot be decided by the arbitrator, that should not go to the arbitrator, my lord. In fact, my lord, 2016.
2016, what did it say?
You are disputing the existence of a contract.
Yes.
No, my lord.
Then?
Because in fact, the partnership agreement was, partnership was dissolved prior to that. Now the question is only with regard to the this settlement of accounts and other these things. But the petitioner herein has lodged an FIR against me, saying that I have misappropriated some funds and I have fraudulently done some mischief with the funds of the partnership. Since these are all of the voluminous records are there, so this cannot be adjudicated by an arbitral tribunal.
No, who has made the allegation? They have made it
They have made it.
against you.
Minor. And they have also filed an FIR, which is also pending, and the case has been already registered, madam. The FIR, your lordship will find in their application, page 12.
Where is the contract?
My lord, your
You,
lordship.
this is the dispute with regard to settlement of accounts
Yes.
Yes, madam.
between the partnership.
Between the partnership. And the partnership was dissolved by virtue of a notice issued by me, the respondent herein, under section 43(1). Prior to this, coming to this notice for arbitration.
All right, then. If we are to hear it, then let us take it up on a different date because it will require some extensive hearing.
I know that.
See, you have you want the matter to be resorted through arbitration. Very well. You have chosen an arbitrator. Now you want the arbitrator to decide on issues where you have yourself filed criminal FIRs,
That does not bar.
criminal matters.
No, that does not bar. So far the criminal case is concerned, that would decide only whether he may be convicted or he may be acquitted.
Right, but
So far the amount is concerned which I have to issue, that can only be decided by the arbitrator.
that can be, but subject to the claim that these are fraudulently taken away.
Even though
siphoned off.
the Honorable Supreme Court has already decided in case, my lord, Swiss Timing Limited. Earlier, I have given this copy of this judgment. my lord.
Yes.
There are 24 of it.
Yes.
24. There are. Keeping in view of the aforesaid observations made by this court in such and such, I see no.
No,
reason-
you start from para 23.
Yes, ma'am. Para 23. This court in such and such rejected the aforesaid submission of the respondent with the following observations. We have carefully considered submission made on behalf of the respective and we are of the view that the learned designated judge exceeded the bounds of his jurisdiction as initiated in such and such. In our view, the learned designated judge was not required to undertake a detailed scrutiny of the merits and demerits of the case, almost as if he was deciding a suit. The learned judge was only required to decide such preliminary issues as to judicial intent in the application. The existence of a valid arbitration agreement, whether a live claim.
Whether a live claim exists.
Yes, live claim. It is the live claim.
So that we'll have to decide before referring it to decide whether the appointment of an arbitrator is necessary.
Yes, That is right. And to that effect, I will satisfy your lordship by even at this stage.
Yes.
A live claim existed or not for the purpose of appointment of arbitrator by the impugned holder much more than what is contemplated under section 11(6) of the Act was sought to be decided without any evidence being adduced by the party. The issue regarding the continued existence of the arbitration agreement, notwithstanding the main agreement itself being declared void, was considered by the 7 judges bench in such and such, and it was held that an arbitration agreement.
No,
could
Mr.
still-
Bhatti will need some time to decide on the merits of this issue. Let us keep it for a fresh day.
Let it be on my lord Thursday.
On
Thursday.
Thursday. Thursday is not possible. We can have it on any week beginning. We can have it on 5th. We can have it on 7th.
In that case, my lord, let it be on 5th, my lord.
5th. All right. Matter be listed on 5th. For hearing.
As the first item in hearing list.
That will not say. You are entitled to make a mention. Be listed on 5th as the matter requires hearing on the question of whether the petition under 11(6) is required to be heard.
Let's
এইকেইটা মাতি দিওঁ ফটাফট।
Items 26 and 27.
May I please the lordship? My lord, the petitioner, my lord, while she was serving an assistant engineer, my lord, she was promoted to the post of assistant executive engineer. And subsequently, my lord, she was reverted back, my lord, without issuing any notice, my lord. And then she approached this honorable court, and this honorable court has been pleased to protect the promotion of the petitioner to the post of assistant executive engineer. And subsequently, my lord, the private respondent, they have also been promoted to the post of assistant executive engineer. And as of today, my
Why
lord,
was he reverted back?
my lord, that order, your lordship will find at page 23, annexure 6, my lord. Without issuing any notice, my lord. Page
23.
Page 23, annexure 6 of WPC number 1064 2016, my lord. The petitioner along with others were reverted back, my lord. The others are the petitioners in the another writ petition, my lord.
Why were they reverted back?
My lord, there was some, that order is at page 21, my lord, annexure 5, my lord. Because it was said that, my lord, DPC, my lord, while considering the vacancy position, there were some anomalies or, my lord, like that, my lord. And the impugned order regarding the petitioner and others at page 22, my lord. Page 22, last paragraph, my lord. The selection board decided to recommend to revert back the following officers to their original cadre, that is the rank of assistant engineer.
Where is the recommendation for promotion?
Recommendation for
Or the order of promotion?
my lord, annexure 1, page 14, my lord. Annexure 1, page 14, my lord.
16. Yes, 16.
So the last paragraph of page 14, my lord, For 24 vacancies of 2023, the name of the petitioner appears at number 7, my lord. Mosumi Kolita.
Yes.
So subsequently, she was promoted, my lord, by the order at page 16 annexure 2, my lord. Thereafter, my lord, without assigning any reason, without showing any show cause notice, she was reverted back, my lord. Promotion order is at page 17.
Only she or the others also?
She, along with these others, my lord, other 6 persons, my lord.
All right.
Page 22, Lord.
Yes. 22.
Yes, my
Page
lord,
22,
22.
7.
Revert back.
Yes.
Yes, madam.
Then
My lord, I approach before your lordship, my lord. And
what
your
is
lord-
the stand of the affidavit? I mean, by the respondents?
Lordship, in my affidavit, if Lordship comes to page 12, Lordship, this is annexure A. Running page is not there. Annexure A.
Of the affidavit?
Yes, Lordship.
Annexure 1.
Annexure A, Lordship. Internal page is 12.
Affidavit filed by?
Filed by the
Respondent number 1, 2,
respondent number 1, 2, 4, and 6, Lordship, by Bijoy Chandra Kolita.
Huh?
Running page to 9.
running page, I got a running page, nothing now.
Sixteen 8/2016 filed.
In which writ petition?
It is WPC 1093 2016.
1093.
Just a second.
1093 only. 1093. Yes.
Annexure A, Lordship. This is letter dated 18th of October 2014, Lordship. To Jatindranath Sharma, Secretary PWA. If Lordship comes to the middle portion, Lordship.
Hmm.
On the other hand, you have accepted, I mean, he was the chairman of the selection board, Lordship, who recommended the petitioner's, Lordship. On the other hand, you have accepted the outstanding in respect of Sri Pradeep Kumar Nath AE of the ACR for the period 2012, Nilotpal Koda. I mean, he did some anomalies, Lordship. This person, Lordship, Jatindranath Sharma. And it was subsequently reviewed. Earlier recommendation, why it was reviewed, Lordship? So far as this petitioner is concerned, Lordship, in case of Srimati Mosumi Kolita AE, you have upgraded the ACR, although the competent accepting authority accepted as very good. It is observed that you have upgraded the remarks to bring her in category A.
This is in the process of selection.
Yes. So this is a promotion on the basis of merit. So for the purpose of giving her promotion to the higher grade, Lordship, her ACR was manipulated. Not just her, Lordship, in case of all the 7 persons. Accordingly, Lordship may kindly see the last paragraph, Lordship. In view of above, it is requested to review the selection process in a transparent manner and judiciously and furnish the review select list to the department at an early date so that no officer are deprived of getting promotion and few officers should not get undue advantage. Lordship, this was done on the basis of complaint received from other assistant engineers. Accordingly, Lordship, a review DPC was conducted, and on the basis of that review DPC, Lordship, it was subsequently, that is the 6th of February 2016. These petitioners have been decided to revert back to their original position. Subsequent thereto, Lordship, they filed these writ petitions, and in the writ petition, Lordship, they were granted interim protection, and they continued in their promotional post, Lordship. Subsequently, they were also given promotion to higher cadres, Lordship.
Who?
This petition.
These petitioners, my lord,
Although-
subsequently they have been promoted to the post of executive engineer also, my lord.
Although
No,
those
this promotion was initially,
Initially,
AE to assistant executive engineer. Subsequently, they were given promotion to executive engineer, but those promotions are subject to outcome of this writ petition. Now, Lordship, on last date, Lordship, when these petitions came up for consideration, they made a submission that as the private respondents have no longer any grievance against the petitioners, Lordship, and they have also continued for a longer period. So they want to.
private respondents are also promoted.
yes, my lord.
Yes,
After reverting the petitioners, my lord, when the petitioners were reverted back, that the private respondents were recommended in their place, my lord. Subsequently, my lord, due to the interim protection passed by this honorable court, my lord, the private respondents as well as the petitioners both were continuing in the post of assistant executive engineer. But the private respondents have been placed above the petitioners, my lord. So if, because private respondents made the submission that if they are placed above the petitioners, then there will not be any grievances on their part, my lord.
So that
even
was, that
the
was their
petitioners-
submission, Lordship.
Petitioners also
But my
accepted that.
understanding is that, Lordship, they are continuing on the basis of an interim order. If this petition is withdrawn, Lordship, that interim order will go. And they have to come down, Lordship, to their original position. So that is why, Lordship, a direction was issued to obtain instruction. Although instruction means we have to take a decision, Lordship, whether we want to condone those anomalies or not, Lordship. That decision has not yet been taken, Lordship. So basically, we stand there as on today, Lord.
This improvement in the ACRs by the chairman,
Then chairman, yes.
then chairman, was unilateral or on representations, or
Not on the basis, it's a collusion actually.
is there any finding to that?
Finding was there, Lordship. In that notice itself, Lordship will say, it was specifically mentioning that person, Lordship. It was stated that you have done this, you have done that. So, to my information, Lordship, a case was also registered against this person, Lordship.
Which person?
This Jatindranath Sharma. Criminal case.
chairman?
Yes. The DPC of which he was the chairman.
Now, assuming that the selection was made on the basis of the gradings in the ACR as it stood then,
Yes.
actual gradings,
Yes.
what would have been the chances of selection of the petitioners in subsequent?
Lordship, in this line, Lordship, it is observed that you have upgraded the remarks.
No, that
of-
we have noticed.
Just to bring her to be eligible for promotion to the next cadre.
What they have done is perhaps they wanted to take an independent view, the selection committee.
No, it was prima facie because if I am the accepting authority, Lordship, and I have accepted the
Who is the accepting authority here?
Lordship, it states, Lordship, although in case of Srimati so and so AE, you have upgraded the ACR, although the competent accepting authority accepted as very good. So it was accepted as very good, but this person manipulated, rewrote
He is not the accepting authority.
No, he rewrote the ACR as outstanding.
Probably he was the reviewing authority now.
So that is the case, Lordship. So today morning also I have reminded the department, Lordship, to take a decision and convey it to me.
What
so
decision?
No, if they are allowed to continue in their promotional post, Lordship, we have to take a decision because it was our decision to revert back to the original post.
But the fact remains that, my lord, without any notice, my lord, the petitioners were reverted back without assigning any reason and notice, my lord. Which is in violation of Article 311, my lord.
You are not terminated.
But reverted back, my lord, without any, once I have been promoted, I have joined, my lord. I have joined my promotional post, my lord. Basically, my lord, it was because of the clashes between two bureaucrats, my lord, officials at that point of time, my lord.
But where are the selection records?
Records I have not, furnished lordship. I have filed my affidavit, whatever is there.
We need to see the records,
Lordship.
including their ACRs,
Yes, that can be placed.
whether the overwriting was done or it was done separately.
Yes, Lordship, that can be placed.
When can you place?
I think one inquiry committee was also constituted, Lordship. That committee conducted an inquiry. If Lordship directs, I can have that copy.
Are you consciously taking a decision in this
Yes,
matter?
we are going to take a decision.
Right. Then let us, how soon can you take a
They
decision?
have already put up the file, Lordship. Today morning I have been informed.
Right, right.
Let them have.
Counsel for the parties. The challenge made in the writ petition is the reversion of the writ petitioners from the post of
Assistant
Executive engineer
to the post
assistant.
of assistant engineer.
assistant executive engineer to the post of assistant engineer. This reversion order is pursuant to the order of promotion given to the petitioners from the post of assistant engineer to the post of assistant executive engineer. Stop. By orders of this court, the reversion order has been stayed and which is still subsisting. Stop. Parties have exchanged their pleadings and the matter is ready for hearing. Stop. Para. Mr. Nayok, learned additional AG for the state, submits that the department is reconsidering the matter and is likely to take a decision in the matter.
No, we are not reconsidering. We are in the process of furnishing instruction in terms of court order.
Where is which order?
Last order, Lordship, I kindly say.
Mr. Nayak submits that in deference to the orders passed by the court. Dated 10/12/2024, where the respondents were directed to take a final decision in the matter. The respondent authority is in the process of considering the matter and for passing a final decision as directed by the court. He prays for further 4 weeks' time. List again after 4 weeks. In the event any decision is taken by the authorities, parties are at liberty to mention the matter and place it before the court. List after 4 weeks.
I appear for 8, 9, 12 and 14.
Mr. D.P. Bora for the petitioner, Mr. Nayak, Regional AG for state, Mr. Reed Das for
8, 9, 12 and 14.
8, 9, 12 and 14. List accordingly.
And I am for prisoner on to the 9th.
Obliged, my lord.
May I please your option? The matter relates to the cancellation of my appointment matter. What happened as per the annexure 1, that is page number 13. There was a conditions of appointments and the qualifications, etc. I have applied for this post of constable matter under BSF. And matter after due and process, I was called for physical test and the medical test. I got selected and I was appointed by the appointment letter. Page 36, Miller.
Page 36.
54 to 59, the appointment letter, 54 minutes.
Yes.
Then, my lord, I was working, suddenly I got a termination letter. That is page 61, my lord. From the review of biodata.
Page number 54 is what? Appointment?
Yes. 54. 54 is the appointment matter. Then 61 is the termination letter after 5 months matter. from the review of the biodata candidates of the above examination, it has been revealed that Sri Ansula Narjari, bearing roll number such and such, was selected against the vacancies reserved for the border district of Assam. I belong to Sunitpur district, Assam, and the rank number such and such, and accordingly was nominated for BSF headquarters New Delhi. Since Sri Ansula Narjari does not belong to the border affected districts, his nomination has been found to be erroneous. Under the circumstances, the selection of Sri Ansula Narjari is withdrawn and his nomination to the BSF is hereby cancelled. Now, my lord, my submission before your lordship, since I belong to Sunitpur district, that is a border district also, and as per their the condition of appointment, my lord, page 15, state-wise vacancies are available for candidate domicile in the state, and reservation also available for candidate domicile in the Naxal and militancy affected area, and select border districts in each CAPS. Now, I am belongs to border district. I am also whole Assam was in the that time, my lord, the militancy affected area in 2013.
Yes.
And after verification also, my lord, they have given the appointment. And since I feel that I am aggrieved, my lord, since my candidature was cancelled after serving 5 months. My lord.
Where is the advertisement?
Affidavit they have filed, they have taken
Advertisement.
advertisement, that is page 13. Man. Page 13.
Where is it mentioned here? Border districts?
My lord, page 15. State-wise vacancies are available for candidates domiciled in the state, and reservation also available for candidates domiciled in Naxal and militancy affected areas, and select border districts. Now they say that the Sunitpur is not a border.
What is page 44?
Page 44. Yes. These are the districts, my lord, border districts.
Sunitpur is not there.
Sunitpur is not there. Say, my lord, in Assam, Dhubri, Kachar and Karimganj, Baksha, Chirang and Kokrajhar and Udalguri. The rest is Arunachal, all. Then other states are there.
It is not there.
It is not there.
Then?
But they have considered my candidature.
Wrongly.
That is their case, my lord. I have gone through the all selections process.
Yes.
My lord, yes, my lord rightly pointed out. My lord, yes, there are two categories. One is from border districts, one is from Naxal states, my lord. My lord, may kindly come to page 46. There are two categories, my lord. One is from the reservation from the border districts. These are the districts: Dhubri, Kasar, Karimganj, Baksha, Chirang, Kokrajhar, and Udalguri. Now, page 46, my lord, come to the below portion, my lord. Assam, entire state.
Entire state.
Naxal affected is entire state. Now, petitioner, my lord, he has got the appointment on the basis of that he is a candidate from the border district, not mentioned about the Naxal states. Assam's post are, my lord, reservation for the my lord, border districts post. Now,
no, from where do you say that? This 44.
Yes.
Then 46.
Yes.
They're part of the advertisement.
Yes, part of the advertisement, yes.
Advertisement.
Yes.
So where is it mentioned in the advertisement that?
No, he entered the form.
He entered the?
He fill up the form, my lord.
Where is that form?
Border district.
That, my lord, affidavit, my earlier councillors filed the affidavit, that is not annexed. But that is the fact, my lord. He has.
Do you at least have a sample of the form to
My
be
lord,
filled?
not at this stage, my lord. I have to then bring the record, my lord. Otherwise, my lord, in the appointment letter itself, my lord, for page 54. Page 54 appointment letter itself, it was mentioned that in case if the verification reveals that the claim of the petitioner belong to any other, my lord, his service will be terminated without any, my lord, notice.
Naxal or militancy area, my lord. At that time, under militancy area, the whole.
Militants, Naxal affected areas, the whole
Some was never Naxal
Assam
area.
and militants affected area, my lord. But petitioner fill up the form as a candidate from the border district.
Where is it mentioned here in the appointment order?
Appointment order, my lord, page 54.
Page 54, my lord, Annexure 3. In pursuance to the.
Two, para 2, my lord. Second,
The appointment is
fourth
for-
line, if the verification reveals that the claim of the belonging to STSC or any other information are found to be false, their service will be terminated forthwith without assigning any reasons and without prejudice of such further action may be taken under the provision of the Indian Penal Code. So, my lord, he has filled up the form as a border district candidate.
So what basis are you saying it?
My lord, that record has to be called for, my lord. As because my lord, earlier some other advocate is conducting the case, my lord.
Produce that record.
My lord, record.
Heard counsel for parties, the writ petition is filed. Assailing the, where is the termination order?
Yes. Termination order, page 61.
64.
61.
61.
Huh? 61.
61.
Sixty-four is my lord, information, intimation.
61. Under circumstances, your also another is withdrawn as nomination.
306.
Yes, sir, yes, yes.
2013, whereby the petitioner who was appointed to the post of BSF
Constable, man.
Constable, BSF,
Yes.
pursuant to a proper selection, his appointment stood cancelled. Stop. According to the counsel for the petitioner, he had applied to the post, he had applied for the selection and appointment pursuant to the advertisement dated
3/12 to 2011, man.
3/12/2011, conducted by the Staff Selection Commission for recruitment of constables within bracket GD in CAPF small s and rifleman GD in Assam Rifles. So, pursuant to the selection, the petitioner was appointed as Constable GD in the BSF. So, according to the petitioner, in the advertisement, it was provided that border states, border districts, and
Militancy and Naxalite.
where militancy and Naxal activities are prevalent, are separately categorized. Stop. The petitioner belongs to the district of Sunitpur. Although he did not, his district was not included in the border districts in the list enclosed. Fact remains that he belongs to a district in the state of Assam, and the entire state of Assam is notified as a state, is included in the list of Naxal/militancy affected districts. Stop. Therefore, the district in which the petitioner, the domicile district of the petitioner, namely Sunitpur, is also considered as a militancy affected district for the purposes of the state of Assam. So, under such circumstances, it is submitted that his reversion, his termination order, cancellation order, cancellation of the appointment order is contrary to the is totally uncalled for, as the authorities fail to take into consideration that notwithstanding the petitioner's domicile district being within quote Sonitpur, not being included in the list of border district, it being a part of the state of Assam, it being a district in the state of Assam, the entire state of Assam is included in the list of Naxal/militancy affected districts. It is therefore submitted that the cancellation order should be interfered with, set aside, and quashed. Mr. K.K. Parasar, learned CDC, appearing for the Union of India, submits that the cancellation of the petitioner's appointment took place in view of the petitioner having stated in his application that he belonged to the border district. Subsequently, on verification, it was found that Sonitpur is not included in the border district in the list enclosed and appended to the advertisement. Consequently, his appointment stood cancelled, and therefore there is no infirmity in the order of cancellation. On a pointed query by the court as to the application form, as to whether the application form filled up by the petitioner is available on record, the learned CDC submits that it is not, but copies of the same would be available in the relevant records. He therefore submits that he be permitted to produce the relevant records containing the application form of the petitioner before the court within
2 weeks minimum.
2 weeks. Matter therefore be listed again after 2 weeks.
Abla.
29.
Yes.
This-
House rent.
Yes, Mayor.
What happened after that?
My lord, I've already read, my lord, these rules 17. Rule 17 is there. This is my additional affidavit is there, my lord. If 17 is personnel allowed to stay in higher accommodation outside the lines will, no, this word, my lord, this allowed, my lord. My lord, first, my lord, if there is non-availability of the quarter, my lord, after, my lord, application, my lord, it is required to allow, my lord, to stay outside, my lord. So this line, these personnel allowed to stay in the hired accommodation outside lines. So the rest is, my lord, not related.
Why don't you read Rule 17?
My lord?
You are referring to Rule 17.
17.
Please read it.
Yes, my lord. The personnel allowed to stay in the hired accommodation outside the lines will not be entitled to the amenities provided the personnel staying in the campus. However, they will be paid normal rent house rent allowances as per existing rule instruction on subject and compensation in lieu of the free accommodation to the extent of the percentage fixed by the government.
So they will be paid.
My lord, first, it is required to allow him to stay in outside, my lord. First word, my lord, the person allowed to stay. Non-ability of this quarter, my lord.
Is there any order to say that his choice to leave to stay outside
Well, thereafter, this
is without permission or was rejected or recalled?
My lord,
is there anything to say that he is not allowed to stay in the accommodation outside without permission?
My lord, this is my lord, this disciplinary organization, this quarter is there, my lord. And the thereafter, my lord, the 25, my lord.
Discipline authority, therefore you have to You have to be disciplined
Yes.
yourself to
Yes,
understand.
but then thereafter about 25. The next phase.
Yes.
25 weeks, and the maximum retention period of the quota is prescribed as 5 years, with a provision that even after posting to attach the battalion of the GC, the retention period will not be extended beyond 5 years in any case. The periodic 5 years extension of CRPF accommodations should not be made applicable to the person posted Northeast region, JK, and so and so and so, so and so. However, 5 years accommodations will be counted from the date of original allotment of.
All right, all right.
So
We'll pass orders.
my humble submission before it is when these, the additional house rent means in original place of posting, at that time he was in hired, as the authority allowed him to stay in outside. So thereafter only the additional house, he will get house rent.
All right.
Your
Heard.
lordship, your
We are
lordship,
closing it. We have heard. Any judgments you want to place?
we have another order, your lordship, after, when he was denied the sanctioning of being in Northeast region, the additional HRA. Later on, when he, again, he was transferred to LWE region, your lordship. And for that also, he was not given the additional house rent allowance, and which
this
is clearly mentioned in this order, your lordship, that any CPF personnel,
CPF,
including CRPF, your lordship.
and there is another OM. And there's another one. Here, HR is allowed on vacation of the government accommodation by families after 3 years retention period. After 3 years, if in quarter, then thereafter only he will entitle additional HR.
All right. Heard, reserved. Yes.
Need legal option. The non-grant of financial upgradation milord under the astute career progression scheme and modified astute career.
Why was it not granted?
Milord, I did not qualify the promotional cadre course 1, and second, they said my ACR was not up to mark, milord. The condition of promotional cadre course was that I should be provided 3 attempts. On 3rd attempt, milord, I qualified. Even then, that was not granted, again saying that my bench, I did not meet the benchmark, milord. That is the whole case. If lordship
Who's
take
your counterpart? This is CGC.
this, milord.
You're employed where?
Milord, I say CISF, milord.
CISF. Yes, CGC. Wait for some time, let them come.
That's it. Can it be the month of last part of August, milord, if lordship?
All right, last part of August.
Milord, any date lordship may fix, milord, hearing date, milord. On 28th, milord, if lordship permits.
28th.
28th, lord.
List on 28th. We are listing it on 28th.
If he is there, milord, we can argue, milord.
No, actually I have no
Record is not available.
28th.
28th.
Yes.
20th August.
May it please your lordship. Also, I'm appearing on behalf of Mr. N. Deka. He has been advised complete bed rest for 2 weeks. He has
Why?
some back pain, and that has triggered his vertigo problem also.
It must have been because of these voluminous files.
Could be, madam, but for last 3 days he's bedridden, and it has triggered his vertigo problem also.
Each time you have to
Let go of this.
go the e-way.
Because
Yes.
of the volume, perhaps.
Huh?
Because of the volume. that
Yes, it's of
trigger-
course, it is absolutely
regarding the
with the volume, but volume of what we don't know.
Lordship,
Big
Definitely-
volume files, the matter is very small
No,
generally.
no,
That's what.
by volume and volume pertaining to papers, but what papers we don't know. So we'll keep it at that.
I'm not engaged in this matter, so I'm not accustomed with the
Right.
facts, but just.
Regarding volume, Lordship, I have responded many times. I have submitted the voluminous petition because of their manipulation. And they did not give any information during the disciplinary process and
How long,
during.
how long is
But
he going?
2 weeks he's been advised. Let it come after 3 weeks.
Lordship, there is-
Hopefully he will be okay by then.
There is a simple clear Lordship.
Will you accept if the court engages a legal aid counsel? You don't have to make any payment.
Lordship, in last occasion, Lordship, I already gone through all those documents and all those facts, Lordship. I am confident that I can.
No, no, we are not even for a moment doubting your competence, but there could be some areas where if a counsel appears, it would be in your interest, but entirely your choice.
But the main issue is that this honorable court in last occasion issue order to give the details and particulars. That order was violated by them.
We'll grant you time for, say, 2 weeks.
Lordship, I have simple clear, Lordship. Lordship, kindly give me a fair opportunity to defend myself and get the information and document from them.
No, no, we will do it, but the gentleman representing the company says he is on medical, he is advised bed rest on medical grounds.
Yes, I acknowledge it, Lordship. But my submission is that since they repeatedly refuse to respond my submission, and they mentioned that in last order, this honorable court limited me to submit my details. So we kindly allow me to submit another affidavit without any limitation, so that I can defend myself and get the required information and required document from them.
You want to increase the volume?
I had last time I hardly submitted a 7-page document, but they did not respond.
You want to file an affidavit?
Yes, Lord.
All right. Heard, learned, come. Mr. What is your name, please?
Avinash Bora.
Avinash Bora, petitioner in person. Mr. H. Das for?
HK Das for 456.
HK Das for 456. And Mr.
DK Bhattacharya on
DK
behalf of
Bhattacharya on behalf of Mr. N. Deka.
For 2 and 3.
For respondents 2 and 3, Mr. Deka submits that Mr. Bhattacharya submits that Mr. Deka is indisposed and has been advised bed rest for 2 weeks. He therefore submits that the matter be deferred to be listed after 3 weeks.
I will
Mr.
submit it.
Bora, on the other end, petitioner in person submits that he be permitted to file an affidavit.
Yes, without any limitation, Lord. Kindly mention it.
What
Otherwise,
is the meaning of that?
Otherwise, they mentioned that this court had limited me to submit this kind of issue only. But they violated
You
the.
file, we are not saying anything, you file whatever you want to file.
Lordship, I'll file it on 18, Lordship.
All right.
Then kindly fix a date for them so that I can get the response before the next
You
date.
want to file it on 18th
Yes,
or by 18th?
By 18, on or before 18, Lordship.
All right. The petitioner in person is permitted to file an affidavit on or before 18th of August. Matter be listed thereafter.
Lordship, kindly pass an order so that I can get the response before the next days of lesson from them, Lordship. Response from them.
We don't know whether they would like to respond or
Kindly
not.
fix it that so that whether they this time if they.
All right. Matter be therefore listed on 3rd of September.
In the meantime, if needed to.
Lordship, kindly fix it that so that.
3rd of September.
Next days of listening is not a matter for me. My concern is that I can get a response from that.
If the petitioner files the affidavit as permitted by on or before 18th, the respondents will positively file their response, if so advised, before the next date fixed, which is
fix it
3rd
date,
of
fix it date.
September.
Otherwise, the last time also this.
We have fixed a date, 3rd of September, the matter will be there. We have indicated if they don't file, we are permitting them to file if they want. That's all.
before 3rd of September. If 3rd of September they will going to submit it, then kindly defer the next date of this thing so that I can at least go through the document.
We'll see that the respondents will ensure the affidavit is filed at least 5 days prior to the next date of listing.
Let it be 5th of September then. We'll get time.
5th of September.
Friday.
Kindly mention last one order that they need to either they need to refuse my submission para wise or sub para wise, or they need to respond my every point.
Mr. Bora, that is why we had suggested that you accept the suggestion of the court for engaging a legal aid counsel, because you can't dictate how one should file an affidavit. Whatever they want to file, if they want to file, they'll file. We are here to decide the matter.
This opportunity was given previously.
All right, one more opportunity we are giving you. But we can't order how they should respond to your affidavit.
Yes, Lordship, but in last order, this honorable court ordered me to, based upon their request only, this honorable court ordered me to submit specific details. When I submit specific details, they did not mention anything. They refused to respond against my submitted point. If this I received a response against my submitted point, then I can easily defend and the next date I will I'm confident that in the next date I will get justice, because last 2 years they falsely mentioned in this honorable court there is no due
Don't use such terms as falsely misleading,
because this affidavit they confirm, Lordship.
All right, enough. We have given you enough time. We are fixing it on 5th of September.
Okay.
If they want to file whatever they want to file, they'll file. We'll take up the matter on 5th September. You are given time to file on or before 18th.
On or before, and they will going to submit
5 days before 5th of September. All right.
Obliged.
With pleasure, Roshi. This is in respect of, my lord, an order of removal from service by the appellate authority. The disciplinary authority imposed the penalty of dismissal from service. Then on appeal, it has been reduced to removal from service. He is, my lord, officer of the State Bank of India. And there is a checkered history of this case. Earlier, my lord, this petition was disposed of by the Honorable Single Judge with certain observations, my lord, remanding the matter back to the appellate authority. Then on appeal, the appeal was filed by the bank. In the appeal, my lord, they had withdrawn it, but one observation was that the appellate authority, while considering, will not be influenced by the findings of the Honorable Single Judge earlier. That is how, my lord, the appellate order came to be passed, and I am challenging with the order.
Where is the appellate order now?
Appellate order, your lordship will find
It's 70.
at page 76. No, sorry, 96. At page 96, no? Yes. No. The appellate order.
No, appellate order there. It's 106.
105.
105 starts 106.
One zero
105, my lord.
5.
The relevant is starts at 106. Now it's a very long order. I'll take your lordship to be, my lord, relevant paragraphs only. Your lordship may kindly read paragraph 1 and 2 first, my lord, just to give an idea of what is the matter about. May I read it, my lord?
Yes.
In compliance to the order dated 31/5/2023.
You're reading the whole order?
No, my lord. Whole order is very long, my lord. I'll read only relevant paragraphs.
Where is the ultimate finding by the.
Ultimate finding is, my lord, the appeal has been rejected.
119, my lord.
Well, what was the direction of the coordinate bench or
My lord, it was remanded back.
in the appeal?
No, my lord, in the, my lord.
Before by a division bench?
My lord, it was remanded back by the, my lord, honorable single judge. Then, my lord, the bank preferred an appeal. Then, my lord, appeal was withdrawn by them, but there was an observation that it will not be influenced by the order of the honorable single judge. Now, the order of the, my lord, honorable single judge is at page 79. The relevant part is, my lord, at page 95, paragraph 29.
Where is the inquiry report?
Inquiry report, your lordship will find at judge sheet, inquiry report at page 41.
Yes.
There were, my lord, 7 allegations, my lord. Out of that,
only one proved, 2 proved.
In fact, my lord, 1, 2,
No, sorry.
4 are, 5 charges are proved, my lord, according to the, my lord, the inquiry officer. The first charge is, my lord, unauthorizedly overdrawing of personal loan, OD account, exceeding 5 lakhs limit. That is the main charge. Then the second charge was, while overdrawing, he posted and passed checks and debit vouchers under his own ID to conceal. Then not proved time, my lord, skipping. Then, my lord, the charge number 4 is some deposit in personal loan account do not commensurate with the petitioner's known source of income. Then some deposits in petitioner's savings account do not commensurate with the petitioner's known source of income. And last charge is petitioner misutilizes his power for personal gain, violating bank's guidelines. My lord, main issue is the, my lord, the charge number 1. And that is where, my lord, the everything hinges. And, my lord, question that falls for determination before lordship, my lord, in my humble submission is that, my lord, I'll take to the, my lord, the circulars of the bank. Because, my lord, the limit was earlier 5 lakhs personal loan. Then it was extended to 7 lakhs. The only allegation, my lord, which has been proved by the inquiry report is that while taking more than 5 lakhs rupees, he did not get the sanction of the higher authorities. So therefore, my lord, the point your lordship.
That is a personal loan for the officer?
Yes, my
delinquent officer?
My
Okay.
So since it was more than 5 lakhs and he did not take the, my lord, approval and sanction of the higher authorities, that is the, my lord, main allegation, I guess, in respect of which, my lord, the entire discussion, my lord, takes place. And, my lord, in my humble submission, my lord, the point that falls for consideration before lordship is that, my lord, whether not taking that, my lord, approval and sanction of the higher authority, whether it is a misconduct within the meaning of the service rules, or it is a, my lord.
The single judge had virtually allowed the writ petition.
But remanded back.
Remanded back. But there were some findings there.
Yes.
Against the order of the division bench, did not proceed in appeal.
My lord, they did not, my lord, they had withdrawn it. They had withdrawn the appeal. The appellate order, your lordship will, I mean, the writ appeal order, your lordship will find at page 96. After arguing the matter for some time, Mr. A.K. Chawla, Learned Counsel representing the appellant bank, submits that as the learned single judge has remanded the matter to the appellate authority to reconsider the appeal of the respondent, it would be apposite to comply with the said direction rather than questioning the same in this writ appeal. Thus, he craves liberty to withdraw the instant appeal. The appellate authority shall reconsider and dispose of the appeal filed by the respondent after providing opportunity of hearing to him and by passing a reasoned order dealing with the grounds of appeal within a period of 6 weeks from today without being influenced by the findings recorded in the order passed by the learned single judge. Now, well, this order was passed on the first day
You
itself.
accepted this.
No, my lord, this was passed, my lord, on the first day without hearing us. But then, my lord, this, I am not really aggrieved by this order also, in as much as the grounds which I urged before the mind of Honorable Single Judge, based on which, my lord, he had remanded back the matter, that though those, my lord, grounds are still open for me to, my lord, submit before worship.
It is open. What we want to know is when the single judge has virtually answered the writ petition in your favor, remanding it back to reconsider. You accepted this order.
My lord, this was an order ex parte.
Ex parte.
My lord.
But no further appeal.
No further appeal, my lord. If your lordship comes to page...
See, the writ appeal was allowed to be withdrawn.
Yes, ma'am.
With this direction.
Yes. Anyway, my lord, but then that does not forbear your lordship from applying your lordship's independent, mine independent.
No, it does not. But what we want to know is when there is an order in your favor,
my lord,
for some reason you are not trying to
page 96, your lordship will kindly see, my lord.
capitalize on that, if that's the right word. What are the grounds on which you are challenging the order? You are challenging now only the order.
The appellate order, my lord.
Only the appellate order.
Yes.
Not the proceedings.
Not the proceedings, my lord, not the proceedings.
Is there any further appellate authority? No.
No. Therefore, your lordship may like to read the, my lord, appellate order and the consider the grounds, my lord, that I urged before.
No, because to find out the correctness of the appellate order, we'll have to read the findings, the orders passed by the disciplinary authority,
yes,
the charges,
yes,
what were the evidence laid. Then, but all these had been answered in your favor in the earlier proceedings.
It was, my lord. But then since the division bench has made this observation, my lord, I have to argue the same, my lord, points before lordship again, my lord.
I don't know.
Because, my lord, the order that has been passed subsequently is also similar to the order, my lord, which was, my lord, challenged in the writ petition primarily.
Where is that order of the appellate authority? Here.
106. Now, my lord, this time the appellate authority has passed a very long order, but mostly, my lord, putting what have been stated in my appeal. Now, my lord, I'd like to draw your lordship's attention, my lord, to page 110. I'll read only, my lord, the submission that was made before the appellate authority and, my lord, what is the finding of the appellate authority. Now, here, my lord, page 110, this was the submission before the, my lord, appellant. That the appellant, one of the, my lord, submissions, may I read it, my lord? Third sentence, the appellant submits that to establish the fact that he was not only the person to post and pass vouchers relating to his overdrawings, but he also wants to mention some of the transactions which are contradictory to the inquiry. On 29/12/2008, check number such and such for ₹5,000 to the limit of 5 lakhs and odd was posted and passed by Mr. T.C. Kakoti. On 8/1/2009, a posting of ₹10,000 was made by R.C. Bora, Special Assistant. Then when the son of Sri Chandran Boisya, branch manager, was going to Kota, Rajasthan to pursue education in Bansal Coaching Institute, for entrance in IIT and needed money for the entrance, Chandan Barbhuya debited his OD account for rupees 32,700 to the limit of 6,34,000. My lord, this was the instances he said that you were singling me out for overdrawing of the personal loan. This is one of the grounds we had taken. Other grounds, my lord, the appellate authority has recorded at my lord page 112. The most important is the my lord, the first submission in serial number 1. In view of the circular number such and such dated 6/2/2008 pertaining to personal loan scheme of the employee of our esteemed bank, wherein in clause 2 it has been provided that considering the overall increase in the prices of consumer goods, durables, etc., the availability of personal loan to the employees falling in his categories to the increase from 5 lakhs to 7 lakhs, that as there was increase in the limit of the personal loan, he was on a bona fide belief or impression regarding entitlement to avail overdrawal facility up to a limit of 7 lakhs, and further that he never crossed the limit of the personal loan of rupees 7 lakhs. Hence, it was permissible for him to avail an overdraw of up to rupees 7 lakhs in his personal loan account, which he had done since his personal loan file containing relevant documents was found to be misplaced, and therefore he could not pursue the procedure and formalities of making an application and getting it formally enhanced and sanctioned. It was basically alleged that he had availed personal loan beyond the sanction limit of 5 lakhs without obtaining any prior sanction for the purpose, although availing personal loan beyond rupees 5 lakh was within the purview of otherwise enhanced limit granted by the circular dated 6/2008 issued by the bank authorities. In doing so, the appellate authority ought to have taken note that the further charge that he had fraudulently misappropriated public money was disproved during the bank's disciplinary proceeding and inquiry itself. Having availed the overdrawal of personal loan which he had otherwise entitled but had not made the requisite application for the sanction thereof, due to the reasons aforementioned, may also be construed to be a minor negligent act which may not amount to a misconduct in the stricter term. Hence, it was only an inadvertent, merely procedural lapse to be complied with, rather than it being a misconduct, and therefore it cannot be deemed to be a misconduct. And as such, even if it is assuming but not admitting that the allegations made against him are true, the same should not be construed or treated to be a misconduct resulting in the harshest punishment for removal from service by the appellate authority. So this was, my lord, the primary ground. Then your lordship might skip the, my lord, other points and the findings. He has again, my lord, repeated at page 116, my lord, the same contentions and other contentions also, which I am not, my lord, troubling your lordship with at the present. Now, page 118 is the, my lord, finding of the appellate authority. May I read, my lord, page 118?
Please read.
The appellate committee observations and submissions dated 14/6/2023 made by the appellant. Most of the submissions made by the appellant in his submission are reiteration of his earlier submission made in his appeal dated 6/3/2012, which have already been commented upon. The appellate committee observes as under. As per Bank's e-circular dated 6/2008, the employees who intend to avail of the personal loan for the revised limit may get the loan sanctioned as a fresh case. Hence, the appellant's submission that due to non-availability of documents from his previous branch, he could not apply for sanction of the enhancement of the revised limit has no merit. Then the overdrawing in his account in various instances, as alleged in allegation number 1, beyond his sanctioned OD limit is an abuse of faith.
So essentially, the single judge coordinate bench earlier held that it was not misconduct per se.
Yes.
It could be an act of negligence.
Yes.
And it is bordering in the periphery of misconduct. So therefore it was sent back. But this finding has lost its force in view of the observation of the division bench.
No, your worship need not go into the findings of the, my lord, the.
So unless we go into it,
My lord.
how do we decide the correctness of the
No, my
the
lord,
appellate authority?
independent of what has been held by the honorable single judge earlier, my lord, your worship is required to, my lord, apply mind and.
We are not required to. We may proceed, we may not proceed. Once the court has decided something in your favor,
My lord.
you toss it across, you don't pursue it. Now you come back again requiring a more definitive or a proper finding. We are not inclined to entertain such petitions. Why should we look into this appellate authority? Appellate authority is, the order is remanded, this matter is remanded to the appellate authority to be decided
Yes.
with certain observations of the single judge, coordinate bench.
No, my lord, the honorable division bench has said that the.
Uninfluenced.
Uninfluenced.
So what is the effect of that?
Uninfluenced, we did not go into what is the finding there, my lord.
Exactly. But this finding was in your favor.
Yes, my lord. Now your worship will give, my lord.
Why should we? Once it has already been done by a coordinate bench, why should we again entail into this exercise of trying to find out what is misconduct, what is not misconduct, whether it is negligent? It has been done. The appeal filed has been withdrawn, but for the observation.
My lord,
you did not, you accepted that.
This is a fresh order, fresh appellate order, my lord. Fresh appellate order.
Fresh appellate order is to be decided. The scope of judicial review there is very limited. Whether the appellate authority is the proper authority, whether the notice has been granted, whether the evidence has been appreciated.
Your worship is right, my lord. But at the same time, my lord, whether the, my lord, the points that have been taken by the appellate authority has been rightly considered or not by the appellate authority, that is.
That we may not be, because you see, we cannot now fall back on the judgment of the coordinate bench. Coordinate bench's findings. Yeah, this was the finding arrived at by the court. However, the appellate authority disregarded this finding and went to decide. That would be a ground to interfere. But these findings will have no bearing in view of the observation by the
that, my lord, that calls for a fresh application of mine on the.
Why should we?
Because, my lord, this is a fresh order. This is under challenge before your worship.
Why should we go into this aspect of what is a misconduct when it is already there in your favor? You have not explained why you have not proceeded, why you have not accepted this order of the single bench. The observations, the findings of the single bench are in your favor.
My lord.
You did not go in appeal.
My lord, I didn't go in appeal.
They went in appeal. They withdrew the appeal.
Yes.
And there is an ex parte observation. You choose not to seek clarification or further appeal. Consequently, the findings arrived at by the coordinate bench has lost its force. And now you're inviting us to do the same thing over and over again.
My lord, let us look into it from a different angle. My lord, appellate authority had passed an order earlier.
That was interfered.
That was interfered, my lord.
Remanded.
Fresh order has been passed.
No, it was remanded in view of the findings given by the single bench as to what would be misconduct under the circumstances, whether it is misconduct per se, or whether it is more in the realm of negligence, whether it would, if it is negligence, then whether the misconduct will sustain, whether there was a loss caused to public exchequer. All these issues were directed to be looked into. But this will have no bearing now. In view
of the observation of the division bench, my lord, the judgment of the honorable single judge earlier gets obliterated.
That's right.
It's, my lord, it's a clean slate now, my lord.
Right. No, we want to know why you are accepting this clean slate when the coordinate bench judgment was in your favor.
My lord, it's a fresh
is he some kind of a persistent litigant who likes to come to court, filing cases after cases? He had come to the court. He had got an order in his favor. As an astute counsel, you know he was not on caveat. Writ appeal was filed, withdrawn, with an observation. And he merrily accepts that observation.
That's why, my lord, this is open for your lordship to, my lord, consider it again, man.
We fail to understand that. That's what we are trying to explain to you why you are giving a go-by to the finding of a coordinate bench
Because
and inviting the court to go through the decisions again. I mean, render a decision again.
Because there is a fresh order, man. Fresh order.
The fresh order, we'll examine it, all right. The records available.
Well,
All right. We'll keep it for a fresh day. Heard so and so, counsel for the parties. List on 26th August. 26th August. Let the records of the case, the records of the proceedings, disciplinary proceedings be also made available, be kept available for perusal of the court if the need so arises.
May I request first week of September, any date, madam?
First week of September.
Any, if my,
No problem, no issue with that.
All right, 2nd September.
great.
The lordship is not keeping us part of it.
There is nothing to part here this matter.
Fine.
You are asking us to act as if we are a super appellate authority to decide on the nuances of the findings of
No,
the
my
appellate
lord, my submission before your lordship is that, my lord, everything has been obliterated because of that ex parte observation. And therefore, my lord, your lordship would like to, my lord.
That's the question which troubles us, that why did you allow the findings of the coordinate bench to be obliterated, which was in your favor?
No,
Perhaps you did not like the findings entirely. That's a different issue.
No, it's not that, my lord. I was happy. And since a fresh order, we know, my lord, the same thing has been repeated, my lord. What has been given the finding in the earlier order, appellate order, is the same thing. Therefore, my lord, same repetition, and my lord,
We'll examine it on 2nd.
all right. 2nd of September.
Okay. 34. Wait, please.
Yes. Morning when you mentioned, did you mention for upgrading the matter?
Yes, sir.
Oh, I'm so sorry.
No, no,
Actually, I
that's
thought.
Is always subject to your lordship's smaller convenience.
No, because we had allowed one upgradation, but I somehow missed that term upgrading, and I thought you were mentioning
No,
it.
but I didn't use that word, my lord. It's your lordship never miss.
Okay.
Well, as per the last order, we had, my lord, exchanged the authorities as well as the list of dates. May I place the list of dates I'd given to your lordship's, my lord?
It's here.
Yes, I'm obliged.
Yes.
Well, let me take your lordship's, my lord, very briefly through the list of dates, and then I'll take your lordship's too, my lord. In the year 2004, my lord, the legislature of the state of Assam passed an act which was known as the Assam Rural Health Regulatory Authority Act 2004, and we'll call it, my lord, ARA Act, my lord, introducing a medical course, namely Diploma Course in Medicine and Rural Health Care. Well, this act had various restrictions. Section 24, my lord, your lordship will recall I pointed out on the last occasion that, my lord, they will treat only what is permissible under the act. They will be licensed to, my lord, practice as rural health practitioner only in the rural areas of the state of Assam, my lord. And they were to be, my lord, conferred this diploma by a recognized institution, which at the time was, my lord, a government institution at Jorat. A notification dated 8/4/2005 came to be issued, my lord, by the Commissioner and Secretary, Government of Assam, Health and Family Welfare Department, Assam, and establish an institution, namely Medical Institute at Jorat, Assam, for imparting the said course. The Assam branch of the Indian Medical Association filed a writ petition with a writ petition number 5789 of 2005 before this honorable court by challenging the constitutional validity of the ARA Act. But because no stay was granted, the admissions continued till 2004. So the admissions were invited by the state through a public advertisement. But toppers of every district, the whole idea was that somehow the government and the legislature felt that the need of the rural areas was that you needed intermediate medical practitioners who could attend to small ailments, if I may use that expression, of various kinds and provide for medical assistance to the most needy in the rural area, at primary health centers, secondary health centers, community health centers, so that the the enough availability of medical practitioners not being there in the rural areas, this was enacted in public interest, and I'll take your lordships to the preamble of that act as well. They invited between 2005 and 9, the petitioners number 1 to 63, the first batch passed out. Your lordship will find it annexure A1. They were registered under the Assam Medical Act 1999 in the state register as not as medical professionals, because this was a recognized qualification of the state, as rural health practitioners. And that is permissible. I'll show to your lordships, in a moment. In the year, for the second batch, which got admitted in 2006, petitioners number 64 to 136 of the second batch passed out. Similarly, in the third batch, which were admitted in 2007 to 11, petitioners number 137 to 201 passed out. In the fourth batch, which is in 2000, admitted in 2008, petitioners number 202 to 267 of the fourth batch passed out. In the year 2009, the fifth batch was admitted, and they passed out in the year 2013, 268 to 323. In the year 2010, again admissions were invited, and petitioners number 324 to 396 were admitted, and they passed out in 2014. The 2011 batch started, admissions were granted, and they passed out in 2015 before the date of the judgment of the division bench of this honorable court. And 397 to 462, the students of the seventh batch successfully completed their course, underwent training, gave examination, and were conferred diploma, and all of them were registered under the state act as rural health practitioners. But the date I've given little ahead of the Guwahati High Court judgment is 30/10/2014. But lordship may like to note it where I have bifurcated the two. But the purpose is for the legal submissions that I place, the fact that the state continued the admissions will not make a difference, whether they passed out before the judgment or after the judgment. Though, those who passed out, in my humble submission, before the delay of the judgment, have definitely a better case because better equities. Not to say that the other ones don't have.
Is there any finding by the court that it will be effective from the date of the judgment?
No, my lord. Now what had happened was we went on our own to, my lord, be implemented as a party. We were not even heard. The applications were rejected.
No,
but fortunately, the Honorable Supreme struck down.
Struck down.
Well, fortunately, the Honorable Supreme Court has come to our rescue by observing and giving a direction in paragraph 25 small Roman 4 that so far as persons who have were engaged as rural health practitioners will continue to practice allopathy medicine in the same manner as they were permitted under the Assam Act. But the Assam Act is defined in paragraph 2 of the judgment. I'll take your lordships to, my lord, if your lordships will, my lord, permit me to go further with this list of dates, my lord. My lord, if your lordship will see, 2012 to 16, petitioners number 463 to 518, between 2013 to 17, 519 to 574, and between 2014 to 2018, 575 of 2609. I must also mention, Malad, at the outset, lest it be said that I have not immediately brought it to your lordship notice, that when the judgment came on 30/10/2014, there were 3 batches which were already admitted, 12, 13, and 14. We were admitted to the course of Diploma in Rural Health, RHP. They unilaterally changed, my lord, our admissions and the registration from RHP to CHO, which is Community Health Officer. My lord, over the page, my lord, a meeting of the Central Council of the Health and Family Welfare Department was held at New Delhi, appreciating the diploma course. My lord, as a matter of fact, my lord, we are like, my lord, those abandoned kids, my lord, orphaned. It was the State Act. The State Act was struck down. The state, no doubt, filed an affidavit before the Honorable Supreme Court supporting. But as a matter of, my lord, this is my understanding as a counsel, that if a State Act is struck down on whatever ground, my lord, normally the state challenges it. Especially in view of the fact that it had done for a laudable purpose. Its efforts were recognized by, my lord, the Central Council of Health, the Central Health Ministry, to the extent that the Central Health Ministry issues, my lord, letters to various secretaries of other departments that you work on the Assam model. Meeting of the Central Council of Health and Family Welfare was held at New Delhi, appreciating the diploma course. 25/3/2008, letter issued by the Deputy Secretary to the Government of India, Ministry of Health and Family regarding recommendations of the National Human Rights Commission of Health. First batch of diploma in rural healthcare students graduate and are registered as rural health practitioners, RHPs. 2010-2010, Office Memorandum issued by the Undersecretary, Health and so Research Department supporting the ARA Act. Well, that's the letter that I was referring to.
Right.
Well, 30/10/2014. Now, the Act is held by Division Bench presided over by Lord, then Justice Buyan, my lord, to hold that it is repugnant to Section 10A, my lord, of the Indian Medical Council Act. Now, my lord, I must at the outset say that that ground has not appealed to the Honorable Supreme Court. And I'll show paragraphs, my lord, where they say that this is an incorrect reasoning. But for different reasonings, which the Honorable Supreme Court has given, the, my lord, striking down of the Act has, my lord, been upheld. Some of the students who were continuing their study under the said Act filed a special leave petition number 32592, 32593 before the Honorable Supreme Court challenging the said judgment and order. So, the students who were, my lord, there, my lord, they filed a petition which is, my lord, titled Barul Islam versus, my lord, the Union of India. On 24th of June 2015, we did a notification issued by the Principal Secretary to the Government of Assam, Health and Family Welfare Department. Those who were working as rural health practitioners under the National Rural Health Mission were notified and redesignated as Community Health Officer, thereby degrading them from medics to paramedics. On 6/8/2015, a notice was issued by the Director of Medical Education, Assam, calling upon the ARA registered candidates to apply for registration as community health professionals on or before 20th of August 2015. On 6/11 and 14/12, two different dates, respondent authorities issued letters and another dated 14/12 for creation of posts for petitioners as rural health practitioners and their place of posting as secondary centers, primary health centers, and community health centers, etc. My lord, I'll place reliance on this letter, my lord. Then, my lord, there are various letters. My lord, the petitioners who were already granted diploma, my lord, filed a petition before this Honorable High Court challenging the 2015 Act. 2015 Act, my lord, provided or meant to provide a continuity of, my lord, the education that was imparted to all those batches who had passed out before the date of the judgment. However, my lord, it sought to degrade them from rural health practitioners to, my lord, paramedics as community health officers. That was transferred by an order of the Honorable Supreme Court, my lord, and withdrawn to their lordships. And both of these, my lord, the SLPs filed by the students who were studying and those, my lord, who had already become rural health practitioners who had filed petition before this Honorable Court challenging the 2015 Act were heard and decided by common judgment and order, my lord, that is dated 24/1/2023. And your lordship will find that at, my lord, item number 17, judgment of the Honorable Apex Court in SLP Civil number 32591, 32592 TO 93 of 2015 in the matter of Barul Islam and others versus the Indian Medical Association and others. However, in paragraph 25 within bracket Roman 4 of the said judgment, the Honorable Apex Court held that the Assam Act of 2015 is a valid piece of legislation as it has removed the basis of the impugned judgment passed by the Guwahati High Court. Further observed that 2015 Medical Act is not in conflict with the Indian Medical Council, there's a typographical error, Council Act 1956, because the said Central Act, namely IMC, does not deal with community health professionals who would practice as allopathic practitioners in the manner permitted under the Assam Act 2004. The petitioner submitted a representation before the Malord consequent upon that judgment, Malord. Malord, I am told, and Malord, I must tell your lordship very frankly, at some point of time, I've seen an opinion. They've taken an opinion from the learned advocate general also. They said that this judgment has to be implemented, Malord, in the true spirit. But however, Malord, they constitute a committee, 3/4/2023, Malord, with a notification to examine the judgment passed by the Honorable Supreme Court and sought suggestions and recommendations within 2 weeks. Malord, as they've done nothing so far and we continue, Malord, our position is, Malord, and Malord, as I take your lordships to my submissions and the judgments of the Honorable Supreme Court and the other documents on record, that, Malord, an act of legislature to which, Malord, we as citizens, Malord, obeyed that act, offered ourselves to the services offered by the state at the instance of the state, Malord. Such an act of legislature, Malord, should not prejudice us, despite the fact that much later, 10 years later, the act has been struck down 5 years after we were, Malord, registered as rural health practitioners, Malord. That's the first, Malord, foundation or the basic, Malord, submission that I'm going to place for your lordship's kind consideration. Malord, in this process, Malord, may I request your lordship to please first have, Malord, the AHARA Act, which your lordship will find it at page 157. Oh, this is only to place for your lordship's consideration as to what was that act, Malord? How did it operate for a period of 10 years? Well, if your lordship kindly has page 158.
Yes.
Your lordship will be pleased to find the preamble.
Yes.
Am I with your lordship?
Yes, yes.
An act to provide for establishment of a regulatory authority in the state of Assam to regulate and register diploma holders in medicine and rural healthcare and their practice of medicine in rural areas, and also to regulate opening of medical institutions for imparting education and training for the course of diploma in medicine and rural healthcare, DMRHC. Malord, if your lordship please has the definition, Malord, section. In section 2, Malord, your lordship may please have 2D. Course means prescribed course of education and training for the diploma in medicine and rural healthcare. Then, Malord, E. Diploma in medicine and rural healthcare means diploma awarded by the authority on successful completion of the course of diploma in medicine and rural healthcare under provisions of the Act. Then please see, Malord, G. Medicine means allopathic medicine but does not include veterinary medicines. H. Medicine and rural healthcare means practice of allopathic medicine and healthcare system in the rural areas in the state of Assam. Medical institute means established under this act for imparting medical education, both theoretical and practical, for the course of diploma in medicine and rural healthcare. Then, Malord, prescribed will be, Malord, useful because section 24 has, Malord, referred to the term prescribed. Prescribed means prescribed by rules framed under the Act. Regulation means regulation made under section 23. L is important. Rural areas means areas not included in a municipal corporation, a municipal board, or a town committee, or any other area notified as urban area. Then, Malord, N. Rural health practitioner means a holder of diploma in medicine and rural health care who has registered himself as such with the authority and obtained a certificate and a registration number. Now, this is also important in my humble submission. 2O, State Register of Rural Health Practitioner means register maintained under Section 17. An expression registered and registration shall be construed accordingly. State means the so and so. Then, my lord, Section 3, my lord, if your lordship may kindly have a bird's eye view of the Act, my lord. Under Section 3, my lord, there is an establishment of an authority. Section 4 directs, my lord, as to who will be the constituents of that authority, my lord. Section 5 is disqualification for being, my lord, member of that authority. Section 6 at page 162. My lord, are the powers and functions of the authority. Then, my lord, Section 7, the minimum standard, my lord, to be prescribed by the authority of the course, the curriculum, the examination in respect of the course, prescribed by regulation, the terms and conditions and norms to be fulfilled, facilities to be provided by a medical institute for imparting education and training for the course of diploma in medicine and rural health. Now, 8, my lord, permission to open a medical institute. Notwithstanding anything contained in this act, or any other law for the time being in force, no person or organization, please mark the words, other than the state government of Assam shall establish a medical institute without the recommendation of the authority and prior and express permission of the state government. So, my lord, all these years there was no such other my lord, authority or a medical institution except the one at Jorat, which was a state institution.
This was specifically for training the rural health practitioners.
Yes,
it's not a medical college.
No, it was later, my lord, declared as a medical college. Every person or organization, my lord, with your lordship's permission, I may skip subsections 2, my lord. They are not very relevant for the purpose, my lord. Then, my lord, powers of inspection under Section 9, withdrawal of recognition, my lord. Then, secretary and other officers and the staff, my lord, of the authority. If you, with your lordship's permission, I may skip and come straight away to.
No, I just want to quickly,
yes, my lord,
sort of understand. Against the orders passed by the division bench, matter went to the Supreme Court.
Lordship.
Supreme Court reversed the judgment of the High Court.
No, it affirmed the judgment of the High Court while not agreeing with the reasons given by the High Court.
Okay. So ultimately, the
Yes.
interference of the act was sustained.
Yes. The, my lord, striking down of the act, holding it to be unconstitutional.
But on different grounds.
Different grounds. Now, the question that falls for your lordship's consideration in my humble and respectful submission are these 3 or 4. 1, my lord, whether the striking down of the act at a later point of time, either on A reason of the High Court, which persuaded the High Court, or B reason, which persuaded the Honorable Supreme Court, my lord, will the effect of the statute continuing during the period of 10 years, my lord, affect the diplomas granted or the registration granted, my lord? In my humble and respectful submission, the answer is found in the judgment of the Honorable Supreme Court, which says it will not affect, my lord, all those, my lord, past and closed transactions as are, my lord, normally referred to in various terms. The second is, my lord, that will an act of legislature work, my lord, to the detriment of those who acted on basis thereof and, my lord, put in their labor, their life, because, my lord, by now, my lord, it was not a, my lord, 3-month, 6-month period training. A full 3-year training plus 6 months of internship. 3.5 years were invested by students, or 4 years, my lord, as we see.
No, what? Of course, we'll sail with
yes,
you.
my lord. I'll make my attempt to assist your lordships.
Once the legislation has been set aside.
Yes, on the ground of lack of legislative competence.
Right, on whatever grounds.
Lordship.
So what is the status of the petitioners now?
Correct.
What is the status?
Well, the status in my humble and respectful submission that the declaration can only be prospective.
But that ought to be, that clarification you ought to have got it.
Well, it's there. It's the state, Mano. That's why I refer to paragraph 25.4. May I take your lordship straightway to that paragraph, Mano?
Yes.
But the judgment of the Honorable Supreme Court starts at page 376. Please have, my lord, page 513. My lord, this discussion starts from paragraph 23. I'll take your lordship. Lordship may pardon me for taking your lordships in reverse order, my lord.
No, that's all right. It's because of the queries put by the court only.
I'm very grateful to your lordship. At page 513.
513.
This is, my lord, small Roman 4. In, my lord, I'm so sorry, my lord. The lordship may for a moment have page 377. Because in that context, my lord, your lordship may have to consider that paragraph. In these appeals.
377.
Yes, paragraph 2.
Yes.
In these appeals, the appellants have assailed the legality and correctness of the order dated 30-10-2014, passed by the Division Bench of the Guwahati High Court in writ petition civil number 5789 of 2005, whereby the High Court, by allowing the writ petition, struck down Assam Rural Health Regulatory Authority Act 2004, hereafter referred to as the Assam Act, or the State Act for the sake of brevity, which was enacted by the Assam State Legislature. Lord, why I read this? Because this will be in the context of paragraph 25.4, the Lord expression used by my lords of the Honorable Supreme Court. Consequently, I'm now at page 513. My lord, with great respect, my lord, our understanding of the judgment and the understanding of the state till some point of time was, my lord, aligned, if I may use that expression. That is why they took opinion, they formed a committee. State, as your lordships know, with your lordships' vast experience, my lord, is an impersonal organization where there are various actors which have their role to play. But something seems to have triggered, my lord, the state not being able to, my lord, continue to hold the view that it did. Because I'll tell your lordship, my lord, there's a solemn declaration by state in an affidavit filed, which led to this directions of continuing our status. I've annexed that entire affidavit before your lordships. Consequently, the subsequent legislation, namely Assam Act of 2015. Now, please mark the difference, how their lordships use. This is in reference to para 2 at page 377. The Assam Community Professionals Registration and Competency Act 2015, enacted pursuant to the judgment of the Guwahati High Court, is a valid piece of legislation, as it has removed the basis of the impugned judgment passed by the Guwahati High Court. The 2015 Act is not in conflict with the Indian Medical Council Act 1956. This is because the Central Act, namely IMC Act 1956, does not deal with community health professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam. So, my lord, before 2015, except the Act of 2004, there was no other act.
So, you mean to say the Assam Act would mean 2004 Act?
It has to be, because, my lord, for two good reasons, my lord, if I may say so with respect, my lord. One, prior to 2015, there was no other act except the 2004 Act. Secondly, their lordships have made it explicitly clear under the Assam Act in the rural areas of the state of Assam. Hence, by separate legislation, the community health professionals have been permitted to practice as such professionals. The said legislation of 2015 is not in conflict with the IMC Act and the rules and the regulations made thereunder. Hence, the Act of 2015 is not hit by entry 66 of List 1 of the Constitution and is within the legislative competence of the state legislature under the 7th schedule of the Constitution. My lord, this begins the discussion which led to this penultimate paragraph, begins at paragraph 22, my lords. Your lordship will please go with me to page 505.
No. Okay. 505.
505. That is part of paragraph 22. But question arose whether the legislature could have passed this act so as which has the effect of overruling your lordship's judgment, my lord. In that context, their lordships examine the issue. Page
That it is
505. my lord.
permissible. That it is permissible to bring a new act.
Yeah, my lord, your lordships have laid down that if the basis of the judgment is removed, my lord, then it is not overreaching, my lord, the High Court's jurisdiction or the court's jurisdiction to render an adjudication, my lord.
Correct, correct.
The legislature cannot directly overrule a judicial decision. Am I with my lords? But when a competent legislature retrospectively removes the substratum or foundation of a judgment to make the decision ineffective, the said exercise is a valid legislative exercise provided it does not transgress on any other constitutional limitation. Such legislative device which removes the vice in previous legislation which has been declared unconstitutional is not considered an encroachment on judicial power, but an instance of abrogation. The power of sovereign legislature to legislate within its field, both prospectively and retrospectively, cannot be questioned. It would be permissible for the legislature to remove a defect in earlier legislation pointed out by a constitutional court in the exercise of its power by way of judicial review. This defect can be removed both retrospectively and prospectively by legislative process, and the previous action can also be validated. But where there is a mere validation without the defect being legislatively removed, the legislative action will amount to overruling the judgment by legislative fiat, which is invalid. In light of the aforesaid discussion, the petitions challenging the virus of the Assam Community Professional Registration and Competency Act 2015, that is transferred case number 24 of 25 of 2018, are liable to be dismissed and are accordingly dismissed. The said act has been enacted. Please mark this, my lord, very important for my purpose. The said act has been enacted with a view to restore the position of the diploma holders in medicine and to give them continuity in service. My lord, we are not practicing privately. We are all engaged by the state itself. If I may say so, my lord, the abandonment has come, which has led to filing of this petition. We were given birth, my lord, if I may use that comparison, by the state. We were cared, our youth, our, my lord, coming into this world was by the state. It is only thereafter, my lord, that something has happened and I am before your lordship.
So who was before the Supreme Court? Members of?
My lord, in two sets. A, the judgment of the, my lord, division bench was challenged by students who were studying. Well, I tell you,
Students of?
Students who were admitted in the diploma of rural healthcare, but who had not yet passed out. My lord, I tell your lordship, my lord, a very good reason, my lord, why it was so. My lord, those students who had already passed out and got the diploma went to the High Court. Say, please implement, please here. But that application was dismissed. I take your lordship to the ground of dismissal. My lord, there was no prayer in the writ petition saying that all those diplomas that were granted, please make them ineffective. Two, it could not have been, my lord, without us being parties. My lord, the mere declaration sought as to validity or invalidity of an act, my lord, and I'll place, my lord, my submissions on basis of certain judgments of the Honorable Supreme Court, starting from the first one, my lord, 1951, a constitution bench, my lord, 7 honorable judges, which, my lord, went into the question of Article 13(1). My lord, your lordship will recall, my lord, that prior to independence, there were laws which were made by the foreign government, my lord, foreign rulers, which had the effect of, my lord, affecting fundamental rights which came to be conferred by the Constitution when it was enacted. Well, there were certain prosecutions filed on basis of those acts. Well, that was challenged before the Bombay High Court on the ground that these laws have become inoperative, void after coming into force of the Constitution, and therefore any prosecution or action on basis of those laws pending will also be rendered to be void. But the Honorable Division Bench of the Bombay High Court held that no, it was done during a point of time when the law was validly in operation. The law is declared to be void on and from a particular date. It will not wipe out the actions which took place at a point of time when the act was validly in force. The Honorable Supreme Court, my lord, the majority, my lord, judgment by my lord Justice Mahajan, my lord, and another judgment, my lord, by another Honorable Judge, my lord, as their lordship then were, my lord, took the view that it will not affect the validity of those prosecutions which were launched at the time when, my lord, the law was validly enforced. My lord, there is a dissent by my lord Justice Fazal Ali, as their lordships then were, saying that even those prosecutions will go. That's how, my lord, I'll take your lordships to that judgment. But the law in my humble submission is consistent, that it will, my lord, affect only from the date of its declaration. My lord, say for example, my lord, it's like, my lord, the doctrine of de facto de jure. If some act has come into force, a person, an authority is created, he is conferred with the power to decide and adjudicate upon certain rights. That law is held to be valid, invalid, or void on the ground of lack of legislative competence, or even on the ground of violation of fundamental rights, my lord, 5 or 10 years down the lane. Well, all those acts that that person or that authority did will not get wiped out, my lord. My lord, the principle analogous to Section 6 of the General Clauses Act, which saves past transaction, will be held applicable, my lord, is my humble and respectful submission. Though, my lord, there is one more judgment, latest one, on the point, which, my lord, didn't accept directly this argument, but, my lord, in another way has, my lord, accepted the argument. I'll place those judgments as well, my lord. Therefore, my lord, if your lordships go back to page 506, we were in the service of the government. And that is why this line, my lord, is very important. The said act has been enacted with a view to restore the position of diploma holders. Well, restoration of position would come only on account of the striking down of the Act of 2004. Otherwise, there is no question of restoring. We were already conferred, my lord, in medicine and to give them continuity in service. The said act has been elected by a valid legislative exercise and does not transgress any other constitutional limitation, and in accordance with entry 25 of list 3 of the 7th schedule, and is not in conflict with the IMC Act 1956 and the rules and regulations made thereunder as per entry 66 of list 1 of the 7th schedule. Before parting with this case, it is necessary to advert to the reasoning of the Division Bench of the High Court, which has held in paragraph 15 of its judgment dated 30-10-2014 that the central legislation, namely the IMC Act, fully covers the field, and therefore the impugned legislation passed by the Assam State Legislature concerning diploma course in allopathic medicine was null and void. In this context, Article 254 of the Constitution has been adverted to, and it has been observed then on account of repugnancy and there being no presidential assent as was required under Article 254, the Assam Act is null and void. We do not think the doctrine of repugnancy governing Article 254 of the Constitution of India would apply in the instant case. Although entry 25 in list 3 of the 7th schedule of the Constitution is in concurrent list, which gives powers to both union as well as the state legislature to pass laws on the subject education, it is significant to note that any such law to be made by the state legislature is subject to inter alia entry 66 of list 1 or the union list of the 7th schedule. Hence, when there is a direct conflict between a state law and the union law in the matter of coordination and determination of standards in higher education, entry 66 of list 1, such as in medical education concerning allopathic medicine or modern medicine, as in the instant case, where the state law is in direct conflict with the union law, the state law cannot have any validity as the state legislature does not possess legislative competence. In other words, the Assam Act and rules and regulations made under the said Act being in conflict with the Indian Medical Council Act 1956 and the rules and regulations made thereunder, the doctrine of repugnancy as such would not apply within the meaning of Article 254 of the Constitution. The finding with regard to constitutionality of Assam Act the Assam Act of 2015 is limited to holding it non-repugnant with Indian Medical Council Act 1956. However, this court is not rendering any finding with regard to any potential conflict with the provisions of the Assam Act 2015 with the National Medical Commission Act 2019. We wish to refer to Directive Principle of State Policy. The framers of the Constitution in Article 47 have directed the union and state governments to regard the improvement of public health as its primary duty. It follows from this directive that the state shall make all possible efforts to ensure equitable access to healthcare services. This effort must be made to progressively realize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health as acknowledged in international conventions and agreements. While the state has every right to devise policies for public health and medical education with due regard to peculiar social and financial considerations, these policies ought not to cause unfair disadvantage to any class of citizens. The citizens residing in rural areas have an equal right to access healthcare services by duly qualified staff. Policies for enhancing access to rural healthcare must not shortchange the citizens residing in rural areas or subject them to direct or indirect forms of unfair discrimination on the basis of their place of birth or residence. Any variation between standards of qualification required for medical practitioners who render services in rural areas or the medical practitioners rendering services in urban or metropolitan areas must prescribe to constitutional value of substantive equality and non-discrimination. We may hasten to add that deciding that particular qualifications for medical practitioners practicing in disparate areas and in disparate fields providing different levels of primary, secondary, or tertiary medical services is within the mandate of expert and statutory authorities entrusted with the said mandate by the Parliament. The above ought to be considered in the spirit of the constitutional goals and statements, subserving as it does the common good of citizenry of our country. Conclusions. In the result, we arrive at the following conclusions. Entry 25 of list 3 of the 7th schedule of the Constitution deals with the subject education, which is in concurrent list under which both the Parliament or the Union Legislature as well as the state legislatures have legislative competence to legislate. However, entry 25 of list 3 is subject to inter alia. Entry 66 of list 1, which is Union list. Entry 66 of list 1 deals with coordination and determination of standards in institution for higher education or research and scientific and technical institutions. Thus, when any law is made under entry 25 of list 3 by state legislature, the same is always subject to entry 66 of list 1. In other words, if any law made by Parliament comes within the scope of entry 66 of list 1, then the state legislation would have to yield to parliamentary law. Thus, where one entry is made subject to another entry, it would imply that out of scope of the former entry, a field of legislation covered by the later entry has been reserved to be specifically dealt with by the appropriate legislature. In the instant case, it is held that IMC Act 1956 is a legislation made by the Parliament for the purpose of coordination and determination of standards in medical education throughout the country. The said law, along with rules and regulations made thereunder, are for the purpose of determination of standards of medical education throughout India. Thus, determination of standards in medical education in India is as per IMC Act 1956, which is central law. This is in respect of modern medicine or allopathic medicine within the scope of entry 66 of list 1 and not under 25 of list 3 of the 7th schedule. Therefore, a state legislature which passes a law in respect of allopathic medicine or modern medicine would be subject to the provisions of the IMC Act 1956 and the rules and regulations made thereunder. This would imply that no state legislature has the legislative competence to pass any law which would be contradictory to or would be in direct conflict with the IMC Act 1956 and the rules and regulations made thereunder. In other words, the standard in medical education insofar as modern medicine or allopathy is concerned, having been set by the IMC Act 1956 and the rules and regulations made thereunder, or by any subsequent act in that regard, such as the Medical Council of India Act 2019, the state legislature has no legislative competence to enact a law which is in conflict with the law setting the standard of medical education in the context of modern medicine or allopathic medicine, which has been determined by parliamentary legislation as well as the rules. In other words, a state legislature has no legislative competence to enact a law in respect of modern medicine or allopathic medicine contrary to the standards that have been determined by the central law. In view of the above conclusions, we hold the decision of Guwahati High Court holding the Assam Act to be null and void is just and proper. However, the Guwahati High Court has held that the state had no legislative competence to enact the Assam Act in view of Article 254 of the Constitution on the premise that IMC Act and rules and regulations made thereunder were holding the field, and hence on the basis of the doctrine of occupied field, the Assam Act was struck down as being repugnant to the central law. In view of the aforesaid conclusion, we are of the view that the said reasoning is incorrect. it is reiterated that the IMC Act and the rules and regulations made thereunder, which are all central legislations, have been enacted having regard to entry 66 of list 1 and would prevail over any state law made by virtue of entry 25 list 3 of the Constitution. 3. Hence, in view of the Indian Medical Council Act 1956 and the rules and regulations made thereunder, the Assam Act, namely the Assam Rural Health Regulatory Authority Act 2004, is declared to be null and void, and in view of the Assam legislature not having the legislative competence to enact the state law. Consequently, the subsequent legislation, namely the Assam Act of 2015, that is the Assam Community Professionals Registration and Competency Act 2015, enacted pursuant to the judgment of the Guwahati High Court, is a valid piece of legislation as it has removed the basis of the impugned judgment passed by the Guwahati High Court. The 2015 Act is also not in conflict with the IMC Act. This is because the Central Act, namely IMC Act 1956, does not deal with community health professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam. Hence, by separate legislation, the community health professionals have been permitted to practice as such professions. The said legislation of 2015 is not in conflict with IMC Act and the rules and regulations made thereunder. Hence, the Act of 2015 is not hit by entry 66 of list 1 of the Constitution and is within the legislative competence of the state legislature under the 7th schedule. In the result, the civil appeals arising out of SLP number so-and-so to so-and-so, as well as transfer case number so-and-so and transfer case number so-and-so stand dismissed, pending applications, if any, shall stand disposed of. Now, Mulad, I may take your, Mulad, such a situation also happened in one of the Mulad 7 sister states. Mulad, what had happened was that, Mulad, your lordships are aware that by constitutional provision, Mulad, the ministers have been defined, or Mulad, the office of minister is created under the Constitution, Mulad, under as a council of minister. But the state enacted a law which had Mulad, parliamentary secretary. That act was challenged, Mulad, before the Honorable Supreme Court. A judgment of Mulad, a bench presided over by, if I mistake not, Justice Chalmeshwar, held that act to be unconstitutional. That was 2004. But there was a subsequent act, 2012, which was enacted on the same line. And the challenge was mounted on the same ground. But in 2018, what the legislature did was it repealed the 2012 Act, but had a saving clause which saved everything, including the offices. It is in that context, that the Honorable Supreme Court, a 3-judge bench, had a decision, 2 of which are the judges who had delivered the present judgment. And that's why, is my assumption, because I had an occasion to argue this matter, that they had the principle, laid down in that judgment. And there is reference to that judgment here, that what is, if there is an act which validly operated, things have to be saved. I'll place that judgment also, which is a 2019 judgment, of the Honorable Supreme Court. But before that,
there is no such saving clause in the 2015 Act.
No, it, according to interpretation of the Honorable Supreme Court, it, saves, it restores the, position of diploma holders. I read that, part. Which was,
that is the finding of the court.
Yes, my lord.
But in the Act itself, there is no such specific saving clause.
I must frankly say no. Oh, that's why I said,
the Act was trying to create a different, what do you say? Different
kind of medical professionals
which are different from the earlier Act.
That seems to be the purpose. If your lordships, will oblige me, and please go back to the Act, What I wanted to point out are 2 very important provisions of the Act which is struck down. One is section 17 at page 171.
Yes.
State Register of Rural Health Practitioners. I may give a little background before I start reading this. Under the Indian Medical Council Act, there is a register of medical practitioners. A person who is born out on a register of my lord, Indian medical practitioners as a medical practitioner under the, my lord, Central Act can ipso facto on basis of his registration in the central register get himself registered under the State Act. Those very provisions provide that anybody who is registered under the state, my lord, register of medical practitioners will not ipso facto get themselves be entitled to be registered under a registered maintained under the Central Act, my lord, because of the fact that it is entry 66 which lays down the standards of, my lord, imparting medical education. So every state, my lord, I am speaking for the present state, my lord, state of Assam has its own State Act which provides for registration of various kinds of medical practitioners. That act has stood the test of time till today, my lord. I don't think there is any challenge laid. The act is in operation. It is this, my lord, state register, my lord, the authority shall cause to be maintained in the prescribed manner and form a register of diploma holders in medicines and rural health care to be known as the State Register of Rural Health Practitioners. It shall be the duty of the Secretary to keep and maintain the State Register of Rural Health Practitioners in accordance with 171, sir. In accordance with provisions of this Act and the rules made thereunder. The State Register of Rural Health Practitioners shall be deemed to be a public document within the meaning of the Indian Evidence Act. Every person on successful completion of the course shall be eligible for enrollment in the State Register of the Rural Health Practitioners on furnishing to the Secretary the proof of such qualification and on payment of such fees as may be prescribed. Every person whose name has been enrolled in the State Register of a Rural Health Practitioner shall be entitled to have a certificate issued by the authority under the hand and seal of the President and Secretary and bearing a registration number and shall be eligible to practice medicine and rural health care in the rural areas of the state of Assam, provided that no rural health practitioner shall use the word doctor or doctor before or after his name. However, he may identify himself as rural health practitioner or RHP. Then please have, my lord, section 24, I'm sorry, at page 176. The rural health practitioners shall be eligible to practice medicine and rural health care subject to the following conditions, namely 1A. They shall treat only those diseases and carry out those procedures which shall be outlined in the rules. B. They shall prescribe only those drugs which shall be outlined in the rules. C. They shall not carry out any surgical procedure, invasion, investigation, or treatment, medical termination of pregnancy, etc., but shall confine themselves to such medical treatment and perform such minor surgery as may be prescribed. They shall practice only in rural areas as defined in the Act. They may issue illness certificate and death certificate. They shall maintain name, address, sex, diagnosis, and the treatment records of all patients treated by them, and they shall not be eligible for employment in hospitals, nursing homes, and health establishment located in urban areas as general duty physicians involved in patient care in OPD, emergency, and indoor services. Lord, may kindly now oblige me and have page 181. Well, these are the regulations of the authority, regulations of 2005, and the preamble states that these are in exercise of powers under section 23 of the Act of 2004. Lordship may please oblige me and have page 182. I'm so sorry. D. Medical institute means an institute for diploma in medicine and rural health care. Then, my lord, please have selection of candidates. There shall be a selection board constituted by the government with the following members for selecting candidates for undergoing 3-year course in medical institute. Director of Medical Education Assam, Joint Director of Medical Education and Principal of Medical Institute, member, Deputy Director of Medical Education Assam, member secretary. The member secretary with the approval of the chairman, Lordship may then please see the eligibility of application. To be eligible for applying to the course, a candidate must fulfill the following conditions: duly pass the qualifying examination with English, physics, chemistry, and biology. she must pass the examination without grace marks in any subject and in the same sitting, and must obtain not less than 50% marks together in physics, chemistry, and biology at the qualifying examination in case of general category, and 40% marks in SC, ST, OBC, and MOBC candidates. Malad, to my limited knowledge, I think this is the same as you require for Malad sitting in examination for Malad, what they now call is a NEET examination, Malad. That you must have these 3 subjects as your major subjects and these minimum calling and no grace marks. Be a citizen of India permanent, we are not concerned. Please go to procedure. Selection of candidates shall be done strictly on merit basis. The merit shall be judged on basis of marks obtained by candidates in physics, chemistry, and biology in the qualifying examinations. Application for admission into course of diploma in medicine and rural healthcare shall be invited from eligible candidates by member secretary of the authority through advertisements in 1 or 2 of the leading newspapers of the state. After submission of application forms will be scrutinized. Application forms of those candidates not fulfilling the eligibility criteria or incomplete application forms will be rejected. List of rejected shall be displayed. From valid applications, a general merit list of all candidates shall be prepared. A district-wise merit list for each of the district and a state-level merit list of each category of reservation shall also be prepared. Those candidates getting same total marks in 3 subjects, physics, chemistry, and biology, their inter-se merit shall be determined by comparing the marks obtained first in biology, then chemistry, then English, then total marks obtained in the qualifying examination. All the efforts in merit list shall be verified thoroughly by the selection board. Final selection waiting list so and so, so forth, so and so. There shall be 100 seats for a session distribution in institute, out of which 47 shall be distributed amongst reserved category candidates and 53 amongst general category candidates. Then, Manoj, please go with me to Manoj, page 201. Minimum standard for medical institute offering diploma.
Yes.
Yes, Malad, 201, my friend wanted me, Malad, to see B. They can only prescribe drugs that have already been indicated in Annexure 2 of the regulation framed by the authority. No rural health practitioner shall use the word doctor or doctor, same as Malad, the statutory provision, before and after his name, but can identify himself herself as rural health practitioner or RHP. They shall be involved in implementation of national programs in combating diseases, outbreak. Malad, this also assume importance because for the first time the government of India after 2004-5 brought in the concept of NHRM, the national NRH, the National Rural Health Mission, and this was a step the legislature thought was in aid of that mission, That is why when they wanted to provide to such a vast area, cater to the medical needs, this was the stopgap arrangement which was thought intermediary level of rural health practitioners who can take care of certain diseases, prescribe certain drugs, carry out certain procedures only, so that the human life, which is very important, gets some medical attention where there was nil till this date. Then, please see the subjects to be taught: anatomy, physiology, community medicine, pathology, pharmacology, medicine, surgery, orthopedics, obstetrics and gynecology, eye and ENT, basic radiology and imaging, basis of forensic and state medicine, basis of human genetics, basis of dentistry. Then, lectures, etc. I'll not detain your lordship, Please see 214, the curriculum. The curriculum of diploma holders in medicine and rural healthcare is oriented towards training students to undertake basic responsibilities of physician of first connect, who is capable of looking after the preventive, primitive and curative aspects of the health in rural areas. The diploma holder shall endeavor to become capable of functioning independently in rural environment, and she should be able to deal with common problems of health and disease in rural population, avoiding non-essential details of specialization. They must know the gravity and seriousness of the disease so that they can refer patients to the primary health centers or district hospitals as early as possible to prevent morbidity and mortality. And then, my lord, see the detail, my lord, what is the curriculum over the pages, my lord. Now, my lord, as I had pointed out to your lordships, my lord, this goes on, my lord, almost till page number, my lord, subject wise, till 248. Now, my lord, at page 249, your lordship will find minimum attendance of 75% to, my lord, each of the theory classes in order to enable them to, my lord, sit in the examination. The procedure for examination is set out, my lord. How various subjects will be taught in which phases, in which years is at page 250. My lord, then please go with me to page 253, Annexure 1. My lord, your lordship will recall that earlier in the Act and the regulations, my lord, I did read out that only those diseases as prescribed in the schedule and only those medicines which are prescribed are entitled to be, my lord, administered by them. My lord, lordship will recall when I read the Act, my lord, section 24 and, my lord, the regulation. This Annexure 1 at page 253 is that acute bacterial infections, febrile illness, diarrhea, dysentery, viral infections, malaria, embiosis, so and so, so and so, so and so. Now, procedures that can be carried out by diploma in medicine and rural. Venipuncture, venesection, application of bandages, dressings, nasogastric intubation, catheterization, peritoneal tap, normal delivery. Operative procedures permitted to be carried out are repair of small wounds by stitching, drainage of abscesses, burn dressing, application of splints in fracture cases, application of tourniquet in case of severe bleeding wound in a limb injury, conduction of delivery, episiotomy, stitching of vaginal tear during labor, drugs that can be prescribed, antacids, H2 receptor blockers, proton pump inhibitors, sucralfate. Then, my lord, only of these, my lord. So, my lord, it was a controlled, my lord, atmosphere for the persons to operate, in the sense not operation in the medical terms, or to persons to
Provide
work
basic-
in rural areas. Basic medical needs. My lord, we also, my lord, have those basic, my lord, first aid boxes. It's something little more than that, but my lord, we are not trained to do that. But these people were, my lord, made to undergo a 3-year course plus a 6-month internship and trained to do that, my lord, is my respectful submission. Please now, my lord, go with me to, I had referred to in the list of dates, my lord, the letter. My lord, Annexure 5, I had mentioned that, my lord, applications were invited, the first of the batch, at page 271 by an advertisement dated 23rd of June 2005. Candidates seeking admission into 3-year course of diploma in medicine and rural healthcare in the Medical Institute at Jorhat for session 2005 may apply in the prescribed form to be obtained from the principal of 3 medical colleges of Assam: Guwahati Medical College, Guwahati; Assam Medical College, Dibrugarh; Silchar Medical College, Silchar, on payment of so and so, then eligibility, etc. So it was pursuant to this, my lord, advertisement issued by the Director of Medical Education, Assam, as we find on page 278, that the first batch applied. My lord, I referred to the, my lord, decision taken by the 9th conference of the Central Council of Health and Family Welfare, which was, my lord, my list of dates, item number, my lord, 4, page 281, my lord. If your lordships oblige me, my lord, please come to page 282. Recommendation or resolution number 2, that all state governments bring out enabling legislation on the lines of the acts passed by Chhattisgarh and Assam states, so as to introduce a 3-year diploma course in medicine and public health in order to provide manpower to address rural healthcare needs. So, my lord, one organ which is, my lord, a my lord, central organ under the Ministry of Health and Family Welfare, my lord, has a different tune.
Is there a similar act in Chhattisgarh?
There is.
What is the status of that?
After this judgment. Well, after this judgment, that has also been struck down. Well, if I may say so, my lord, before we had the Advocates Act of 1961, my lord, you had wakils, pleaders, etc. practicing at Muktars, everything. Now, if my lord, the state were to, my lord, I dare say, my lord, we will be the first persons as member of the present community under the 1961 Act to challenge, my lord. There is a kind of a professional competition, my lord. But my lord, in the end, my lord, the sufferers are the persons who will be receiving this in the rural areas, my lord. It has been struck down after the judgment. I am told, my lord, I'll make that inquiry and give that exactly.
Because
yes,
I
it is
saw
referred to
reference
here.
of Chhattisgarh, therefore I was
Yes.
just asking.
Then, my lord, please go to the next page, 283. This is by the Deputy Secretary to Secretary, Government of Assam. Recommendations of National Human Rights Commission on Health. I am directed to say that National Human Rights Commission, with a view to ensure right to health and availability of health practitioners in rural areas, inter alia, has made the following recommendations. Medical Council of India should design a 3-year course for training doctors on basic, preventive and curative health services so that paucity or non-availability of manpower is taken care. Another alternative is to have 1-year bridge course for Indian system of medicine and post them at CSCs and PHCs. To discuss the implementation of the above recommendation of NHRC, a meeting was held at NHRC under chairmanship of Justice Shivraj Patil, member NHRC, with representatives of the Medical Council of India, Nursing Council of India, Ministry of Health and Family Welfare. After detailed discussion, it was decided that all state governments may consider enacting suitable legislation on the lines of Assam Rural Health Act, which provide for 3-year course in medicine and public health to practice within the state to overcome dearth of manpower of doctors in rural areas. In this regard, your attention is also invited to the meeting of the Central Council of Health and Family Welfare held on 13/11/2007 in New Delhi, in which states have agreed that such a 3-year course should be started, which would be outside the purview of MCI. In view of the above, in order to enable us to examine the matter further, you are requested to furnish information to this ministry on the following points. The course contains syllabus of 3-year medical course being conducted in your state under provisions of the Assam Rural Health Act, name of places where the state course is being conducted, name of affiliating university, regulatory authority recognizing this qualification may also be intimated, whether the course is being imparted by medical faculties, if not prescribed qualifications for the facilities to teach students, how medical practice being done by medical practitioner is being regulated. You are requested to send us 2 copies of the Assam Rural Health Act along with the relevant rules and guidelines. Then, my lord, at page, my lord, 287.
Yes.
There is an office memorandum issued by the Undersecretary of my lord, the Health. Subject the Assam Rural Health Act ex post facto assent of the President. The undersigned is directed to refer to Ministry of Home Affairs dated June 2010 on the subject so far as the Department of Health and Research is concerned. Comments are below. The Department of Health Research supports the Act in principle. Rules framed thereunder may include the following: provision to monitor and evaluate the rural health practitioner scheme, to organize refresher trainings based on which registration would be extended. Well, even when there are conflicts, this document is placed to show that the thinking process in the government, is reflecting one particular constitutional set of political ideology or political will, and what is actually happening in the ground and in court is something else. When this challenge was there, it appears from this document, that the state realized that if they say that there is a central act, you can always, if there is concurrent power or there is an act which falls within legislative competence on basis of a list in a concurrent list, you may always reserve it for the assent of the President before coming into force. In Escorts Act 1988, the Supreme Court also formulated the principle of ex post facto sanction. It was in connection with, my lord, the prosecution under the FERA Act. My lord, therefore, the state sent it. When it was examined in the center, they said, yes, we are agreeable in principle. This was, my lord, that office memorandum. It is sent to, my lord, the Governor of Assam and Under Secretary of the Department of Health and Family Welfare.
What was the stand of the government before the apex court?
Yes, my lord, I'm obliged for your lordship's that query. Please have the affidavit, my lord. Well, nothing better can be said than the affidavit itself, my lord. If your lordship please sees the affidavit of the state government. Just give me the page, please. Yes, please come to page 357. Well, please come to page 358, para 4. That it is submitted before this honorable court.
358.
358, paragraph 4. This is an affidavit, my lord, affirmed by them, my lord, on 2nd day of March 2016. That it is submitted before this honorable court that in order to address the issue of acute scarcity of doctors in the rural areas, the state of Assam sought to introduce a short-term course in medicine for creating a cadre of health professionals for rendering basic primary health care to underserved rural population to deliver services with a defined package of primary health care. The Assam legislature thereafter enacted the Assam Rural Regulatory Authority Act 2004, which came into effect from 18 September 2004. The ARA Act envisages a medical course prescribing education and training for diploma in medical and rural healthcare. The Act contemplates that a person who passes out course is eligible for a diploma certificate to be awarded by the ARA, established under the ARA Act. The state of Assam constituted the ARA and introduced 3 years diploma course and rural medicine course in 2005 under the provision of the ARA Act 2004 for creation of a set of health professionals to provide healthcare services in rural areas of Assam. The students, after completing the 3-year course, had to undergo 6 months internship training, and then they are registered under the rural health practitioners under ARA. The RHPs were appointed on contractual basis in various sub-centers under the NHRM and National Health Mission. Pursuant to provisions of the ARA Act, an institute for training was established at Jorhat, Assam. State of Assam was of the view that the course approved by the Indian Medical Council are degrees in medicine and other higher degrees, whereas the ARA Act envisages a diploma course with certain restrictions on the medical practitioners who obtain a diploma mainly with an intention to see that practitioners are capable to treat common diseases that affect rural people. The practitioners under the ARA Act are not entitled to operate major surgeries. They are permitted only to treat certain types of diseases and prescribe certain types of medicines. During discussion on the issue of scarcity of doctors in the rural area, 9th Conference of Central Health Council and Family Welfare, November 13, it was stated that the state of Assam and Chhattisgarh have introduced a short-term rural course by adopting respective state legislation. Some of the participants were of the view that such a course could be introduced by other states. On basis of these deliberations, the Central Council passed a resolution to the effect that all state governments shall bring out enabling legislation on the lines of the Act passed by the Chhattisgarh and Assam so as to introduce a 3-year course. Then, my lord, please come to, they refer in paragraph 15 to the judgment dated 30th October. Then, my lord, please see page 361. In view of this judgment, my lord, they quote the judgment of the Honorable Division Bench. The future of rural health practitioners who were working under NRHM and NHM and of those who have completed course but not yet appointed and those who are still pursuing the course after their admission till 2015 becomes uncertain. In the meantime, government approved a new course called BSc CH Community Health course for creation of a middle level career of public health professionals. As per guidelines of the said course, the passed out graduates of BHC Community Health course shall be appointed as community health officer in sub-centers. In view of the above state cabinet, in order to protect the future career of RHP, as well as those who have already completed or still pursued the DMRHC course and who are admitted on or before the session 2014, to make their status same with that of BSc graduates, proposed for introduction of the Assam Community Health and Professional so-and-so Bill 2015. Subsequently, it has been enacted as an act on 29 May. that it is submitted before this honorable court that the Assam Community Health Professional Act did not provide for community health professionals who completed BHC CH course to have right to independently practice modern medicine in order to treat common diseases, but rather they were to assist the medical officers. On the other hand, the ARA enabled the diploma holders to independently practice medicine to treat common diseases with certain limitation. There now this is important. Therefore, vacuum created by non-availability of registered medical practitioners in rural areas cannot be effectively addressed without permitting community health professionals to practice modern medicine to treat common diseases that are easily treatable at the primary level. It is now opined that if after introduction of the course of BSc Community Health, the graduates are not allowed to practice modern medicine, albeit in a limited way, then the intent and purpose of introduction of the short-term course will not be fully served. The state of Assam relies on the dictum as laid down by the Honorable Supreme Court in Dr. Mukherjee Chand versus State of Punjab. Well, that was a case where, my lord, the question was whether Hakims, Vaids, etc., practicing Ayurveda, Unani, or Indian system of medicine could prescribe allopathic drugs. And now the Honorable Supreme Court said, yes, you can, which provides as follows. Because prescribing a drug is concomitant right to practice a system of medicine. Therefore, in a broad sense, the right to prescribe a drug of a system of medicine would be synonymous with the right to practice that system of medicine. In that sense, the right to prescribe an allopathic drug cannot be wholly diverse from the claim to practice allopathic medicine. Further, the state of Assam also relies upon the judgment as laid down by this honorable court in Civil Appeal number 152 of 1994, Subhashish Bakshi versus State of West Bengal, Medical Council and others, which has followed judgment rendered by this honorable court in Dr. Mukherjee Chand. The state of Assam also seeks to bring to notice of this honorable court the division bench of the Honorable Calcutta High Court in writ petition so and so is reiterated that persons holding diploma and employed to man the health centers and subsidiary health centers would be competent to treat common diseases among rural population, including communicable diseases, malnourished states, snake bite, insecticidal poisoning, etc. That on basis of the above mentioned environment, it is submitted to the honorable this honorable court that the answering respondent of the view that erstwhile Assam Rural Regulatory Authority Act is better suited to address the acute shortage of doctors in rural areas. Given this submission, the answering respondent herein agrees with the prayers made by the petitioner in the instant matter. This is the stand, Molo. May I continue tomorrow, Molo? Subject to your lordships. And please see the additional affidavit. Tomorrow or day after, Molo.
We'll
Subject
have
to
to
your
give you
lordships.
some other dates. Tomorrow we are having a swearing in the morning.
Yes, Molo, I was told.
There's a miscellaneous day, so.
But can I, to keep the continuity, take my chance on Thursday, Molo, so I could conclude? As Molo, I had indicated that day also, Molo, I had some eventuality in mind. That's why I prayed for a Tuesday. Last time it was a Thursday, which was on 5th.
You'll
But
have to
Molo,
can we have it on the first week of August? I mean, if it's convenient for you.
Molo, there are two matters. Well, special effects. One before the division bench of the Delhi High Court and one before the Honorable Supreme Court.
Thursday, this court is not available.
Then, Molo, the week thereafter, Molo.
Yeah, that's what. So that will be the first week of August.
No, the week thereafter.
Second week.
Or could it be the first Tuesday?
12th.
12th, Molo.
All right. 12th.
Well, there was I'm not detaining you, Lordship. I dare not, Malad.
No.
Only to indicate, Malad, that page 365 in that Malad continuation, only I just indicate and stop at that and I'll resume, is the second affidavit, Malad, reiterating the stand. And the most important is, Malad, the answering respondent state respectfully submits that the answering respondent would take necessary action to align responsibilities of CHOs with Section 32 of the NMC Act 2019, because Malad, there came the National Medical Council Act 2019. After regulations are framed, irrespective of whether existing ACHP continues to be enforced or in the change scenario, this Honorable Court decides in favor of ARA. Now, that's how, Malad, that line comes in the judgment that even the state wants continuity and to restore. It has not, Malad, with respect come out of, is bound to come out on base of the record, Malad.
No, I just want to understand.
Lordship, please.
The apex court has already held that this the
Correct, but what
subsequent
they,
act.
well, correct, but what they are doing is treating us a grade lower, my lord, and have removed us from the primary health centers and CHCs and brought us to sub-centers. And my lord, now as my lord, whenever my lord, we see an ambulance going, my lord, you have paramedics helping. We have been brought down to that level.
Because, my lord, in the new act, the functions and competency of these professionals have been defined, my lord. So you are going by this new act only, my lord. What they can do, my lord, what is their competency in the field, my lord. That
And
has
this
been
affidavit
defined in
is
the
of
new-
2021, 12th January 2021. I'll take your lordship to the relevant paragraphs. my lord. I'm very grateful, my lord. My lord, may I have your lordship's indulgence to mention on that day in case
Yes,
it
yes,
is.
please do. And please mention that you want an upgrade.
Yes, my lord, I do that, my lord. Now, my lord, and my lord, my instructing counsel, my lord, suggests, my lord, that's, my lord, I assume would be the practice. That if it is listed as parted, it will come up automatically.
Yes, yes, it's parted.
My lord, if your lordship may kindly be pleased to indicate that, my lord.
Okay, heard Mr.
Raval.
P. Rawal.
No, Harin.
Harin
Yes.
Rawal.
I'm so sorry.
Harin Rawal, assisted by Mr.
Adil Ahmed and
Adil
Mr. Mazumdar, who's on the
Mazumdar.
call.
The counsel for the petitioner. The hearing remained inconclusive. Let the matter be listed again on 12th.
12th. I'll be
12th.
very grateful.
As a parted.
Much.
Mr. D.P. Bora is for the respondent authorities. List accordingly.
Lordship.